Someone make it make sense.
Probably a couple.
Hello, my friends. Hold on. Dehumidifier off. All right. Switching from lesson mode to law mode. Here we go. Excelente. Let's get our music going. Oh, so nice. I hope you guys have had a lovely Sunday. Do. Hello. Oh, hi. Hi. We have a new friend. Shout out to Abby Crossing. I know you very well from STS. Were you at Crime Con? Or was that a different Abby? Shout out to all my friends. Shout out to Candace. Shout out to Super Planner Girl. Shout out to DSN. Shout out to Blackwater. Love all of y'all. Hold on. Nightbot, are you working? Nightbot? We need an Abby. We do. We need an Abby command. Yeah, Abby. I know you've not been here before. You're probably like, what the hell is happening? Everyone gets a command here. Even my mom is here. Shout out to Schmommers. Also, Nightbot has to hug everybody. Oh, Nightbot, that is so cute, Nightbot. So happy to see all you guys. So yeah, Abby, everyone gets a command here. Hopefully you feel super welcome. We have the best squirrel crew on the planet. And look, Abby's already figuring out how the commands work over here. I guess some of them are, there's an overlap, right? From STS. Also, hold on. Shout out to all the STS peeps. Bam. And shout out to STS Gang Gang. Oh, we also have a Jeff command. Mom, I hope you had a good day. And everybody, I hope you had a good day. I'm super excited. I love having new friends. We love it here. We love the Squirrel Crew. So many good positive vibes. I was thinking about this. What was I thinking about this for? Okay, you know what it was, y'all? Here's what it was. So, oh, I'm glad, Mom. That's awesome. My mom had a great day, guys. Yay. Bizarre day. I love that description because that can mean so many different things. Sometimes bizarre days are the best days. I'm pausing my music. So I just wanted to say something real quick. So this is not meant to be heavy or whatever. I just was thinking about this like earlier today. So y'all who were aware of what was going on with Chad yesterday, which is probably everybody here, and the way that it was so bizarre. Speaking of bizarre day, yesterday was a bizarre day. We're so excited to have you here, Abby. And just think about, like, we have so many commands, like also, okay, commands, hold on. We have so many commands. So just think about what you want your commands to be, and then you shall have one. And also feel free to join the Discord. We love the Discord is awesome. We have the best time on the Discord. So yeah, it was weird with Chad, how Pryor did not do anything for now, of course, this would have been driven by Chad. I was thinking about a lot of things. I was going down memory lane and I was remembering how Chad Pryor was not death penalty qualified. Do you guys remember that? And that was a big deal because you're supposed to have a death penalty qualified, attorney, especially if they're court appointed. And you have to, the defendant has to like sign stuff in order to have an attorney who's not a death penalty qualified attorney. But I can guarantee you that John Pryor wanted to put on mitigating evidence during the sentencing phase. I guarantee you he wanted to pull the jury. Like, and it's interesting because it's so bizarre. The way that all that happened is so bizarre that you could almost feel like, I mean, unless, see, here's the thing. It's like, I mean, maybe unless there's a strategy. Okay. What one could say is well, maybe this is to try to be able to file for ineffective assistance of counsel. However, that's the problem with waiving your rights. Public service announcement, real quick, while we're talking about that. Y'all, once you waive a right, you don't get it back, ever. Okay? So that doesn't matter if you're in court and you're on the stand and you're pleading the fifth, or you're waiving your Fifth Amendment right, or you're waiving your right to take the stand, or you're waiving your right to not take the stand, or you're waiving your right to present mitigating evidence during sentencing phase, or you're waiving your right to an attorney for all of the things. You waive it, it's gone. You cannot get it back. That is why the biggest thing you can take away from this PSA is I don't care what happens. If you are ever in a position where, even pre-Miranda, if you're in a room with a investigator, a detective, law enforcement, and they're going to ask you questions, all you need to know is one word. Say it loud, say it proud, attorney, and get yourself that attorney, because once you waive that right, you cannot get it back. So, Blackwater said she's lonely because she hasn't seen an adult in 10 hours. Well, I know you can't see us, but we love you. Yeah, that whole thing with him not standing was insane. That is a fact, an actual fact. We are the bestest of the best. Facts. Blackwater, we love you so much. It's 2 a.m. there. She can't get enough. Love it. Love it. So, okay. So it's interesting, right? It's like, okay, but the reason I'm thinking, well, it can't really be for ineffective assistance of counsel is because, well, he waived all that. So he waived all his rights to do so. I would imagine that there's such a thorough record been made. And by the way, every time I check for BK document updates, Chad is right underneath, as most of you guys have seen. I always check for new Chad updates since the trial, start. There's nothing new there. There will be, though. There will be. Because I know that death warrant, for example, should be coming out fairly soon, for just even among other things. We love you so much. Our power is combined, right? Like the Power Rangers. Our power is squirreliness. But here's what I wanted to say. So I was running some errands and stuff like that today, and I was listening, because sometimes it's like I'll be listening and not watching, right, to trial related things. I was listening to this story about this fellow. Actually, do you guys remember the name Reagan Toke? I feel like we might have talked about her on SDS. She was out of Ohio, and she was like an Ohio State University student, and she was murdered. And so the story, just kind of like, I guess it was the story about her trial and the guy who did it and whatever, and he was convicted. So it was a death penalty case. They sought the death penalty for this fellow because he was a repeat offender who had been all over the place doing terrible things. And it turns out he actually had an ankle monitor on when he murdered her and did other terrible things. And so the little ankle monitor led them right to him. So there's that. But that's exactly right. It's a squangwin. It's a squangwin. Oh, wait, I have the wrong. I'm glad you said that. I have the wrong intro slide up, don't I? I was like, wait, it's a snow squangwin. That's the wrong case. What happens when you follow more than one thing? So we need this one. We're not in Idaho yet. We need to be in Idaho. We're in the wrong state. Hold on. Let's fix that. There we go. Now we're in Idaho. See, Sparkle Squangwin is the correct squangwin. All right. So anyway, so this fellow had been wearing this ankle monitor. And so this case was really interesting, guys, because there's a lot of overlaps here with BK, okay? And with Chad Daybell, because it's a death penalty case, first of all. But this fellow had court-appointed attorneys, public defenders, and awesome, Abby. And they were fire. They were awesome. They brought forth, this was a dude who had nothing going for him, who was a repeat offender, like unlike BK, right? Had this whole history, was wearing this ankle monitor when he committed this crime, was in, he spoke to the police, he was interrogated, it was a disaster of an interrogation, all this. I'm telling you, I was so pleasantly surprised. It was moving, actually, because these attorneys, it was like there's another Ann Taylor in a way, right? Like, I was noticing from the get-go, like, he had this young female attorney, and she looked like she had her game face on, y'all. I was like, what? Oh my God. The closing arguments for that trial were so compelling, were so good, but not nearly as good as during the sentencing phase. And this is a death penalty case. That's why I'm bringing this up. So this is the power. This is the point of this. Is this? Here's what the impression that's left me with. This is the power of compassion. Okay, so check it out. So he gets found guilty, right? Okay. They shift gears right into the sentencing phase, like we saw with Chad, and what may be the case for BK if he gets convicted, if he gets found guilty, and if death penalty remains on the table. So they shift right into that, and they do put on, unlike Chad, right? They put on one witness, the defense does, one witness, just one expert witness who talks about places where the state could have intervened or whatever. It was the kind of thing where it's like, he'd been abused himself and all this other stuff, right? Mitigating factors, but just one witness, just one witness. But the witness was very credible and did a really good job. But I don't even think that's what the thing was. I think the thing was his attorney. When his attorney gave the closing arguments for the sentencing phase, you guys, I don't know how anyone can watch it and not get emotional. I only saw a snippet of it. Holy crap. This lady attorney, I don't remember her name. Again, I was driving. Oh my God. It was really, I'm telling you, this is what I'm getting about. This is the thing that I'm picking up on for when people say, like, how can people defend so-and-so and so-and-so, whatever. Someone like this and someone like Ann Taylor who truly believes in what they're saying, and especially when they're court appointed for a death penalty homicide case, like, and they do such a job, you have to think about it. In my mind, it's like they're Mother Teresa. They're like Mahatma Gandhi. They're like it is easy. I mean, okay, like, in a way, right? Relatively speaking, if you compare it to, it's not hard to have compassion for victims. Everyone should have compassion for victims, and I hope everyone does, right? It is a lot harder to have compassion for somebody who is the defendant and who has done these different things, has been accused, or if you're talking about sentencing phase, they've been convicted. To have compassion for them and genuinely mean it, this is what it left me with, because her closing arguments were so powerful and she was emotional and it was so genuine. And I had this feeling, I only heard the last sentence of that, and I knew right then, I was like, they're going to give him life. They're going to give him life. And that's all it took, was a little compassion. They're going to give him life. Sure enough, they come back and they gave him life. She saved his life. She saved his life. And here's what it left me with, was this really strong feeling of, first of all, they just put on one witness, but it was her closing arguments in the sentencing that saved his life. And Chad's attorney couldn't do that for him, even though he hired him. But also, I was thinking about how in a trial or anywhere, hate can be very contagious, right? Hatred, vitriol. And a lot of times I understand that, right? For victims and for victims' families, of course it's justified. And so it turns into hatred for the person, for the defendant. And they make it about hatred for that person. And again, I get it. It's understandable, right? However, what we have to think about is the bigger picture, because hatred is contagious. that vibe, that sentiment is contagious. That negativity is contagious. But what this was such a great example of is, I guarantee you those jurors, they had the hatred. I guarantee you after because the prosecution did great too. I guarantee you after the prosecution went, I guarantee you they had the hatred. Like, I guarantee you they felt the hatred. But you know what hatred was no match for? Hatred was no match for compassion. It was a beautiful reminder, because this attorney came in and I didn't even see much. It was just like the last sentence, but you could feel her genuine compassion. And I guarantee you that's what changed it. And it was such a beautiful reminder and a beautiful example that compassion is also contagious. And between the two, compassion will win. And I thought to myself, that is what we need. That is what the world, like as a human race, as a society, that's what's meant. Like that compassion, like, by which I mean specifically, I thought about this as I was driving. I was thinking about how, like, there's, an eye for an eye, right? Justice. Okay. What is justice? So justice, okay. Does justice mean punishing somebody as much as they hurt somebody else? Because if everybody treats and this is really important, right? Because we're dealing with all these death penalty cases, right? We just had Chad. This is the death penalty case that we're talking about tonight. If we have a mindset, a mentality or a philosophy of like, punish everybody the same way they hurt somebody else, there will be nothing left, y'all. And what I mean is I'm saying, like, going beyond religion, going beyond ethics, going beyond anything else. The way that hatred and vitriol and vengeance, even if it's justified, even if it's understandable, the way that impacts and spreads, that's one option. But I don't know that anybody ever gets anything out of it. I would say my personal opinion is that they don't, but they might think they could. However, compassion towards our fellow human, even if they don't deserve it, and showing them better than they showed somebody else, that is the way. And I just, that's what I hope people can start to understand a little bit, if any of that makes sense. Hopefully some of that makes sense. But it really reminded, like, I've always felt that way, but that was just a really good example of it. And, oh, we've got a command for DSN. Hold on. I've been just talking. Hang on. DSN command. Right. Abby's new to these fun things that we also have. Hold on. Doop, doop, doop.
Hey, he's got a bird in his mouth. This is a chicken. It's a guinea.
We have all the fun here. In the middle of talking about crazy, heavy things. Shout out to the road trip crew. Also, see, we can go from talking about things like the death penalty to poot surprise, and it's all good. Here, for the full effect. It's a poot surprise. Were you guys surprised? Right? I know. We were talking, okay, right? So your mom's favorite store and your mom's haircut. That's funny. And also, for anyone who missed it yesterday, we were doing a Desert Island. Was it yesterday? Desert Island question. If you guys have to pick one favorite attorney between Yannetti and Jackson, some of you guys were here and already answered, and some of you guys probably didn't answer because it's one of the hardest Desert Island questions ever. We followed that up with like blind versus deaf, among other things. But yes, I mean, I think it's just so important. Like what these attorneys are doing, like there's a level of like in terms of protecting the rights and stuff like that. But the thing that gets to the heart of it and why it really matters to me anyway, beyond even the legal implications and people's rights and all that, which on a broader level, like the thing that existed before that, the thing that existed in humanity before we even had written law, before we even had written language as a species, compassion towards one another. And we can see this even in like the animal kingdom. So that's a great example, right? Like this is not, we're talking prior to humans, right? Not prior as in the attorney. We're talking prior to human existence. We're talking these ideas, you know, compassion for our fellow living thing. Like we can even say it's not even about humans, compassion for another living thing. It is so important. And I think it's so important to remember that that doesn't hurt anybody. Like that just helps. Like having compassion is only a good thing, and an eye for an eye is not the way forward. I'm glad Abby's like, yeah, I get what you're saying. Awesome. Glad. Oh, look, you guys were way ahead of me. I'm still catching up on the chat. Okay, well, here we go. So I must have read minds, but in hindsight. Yeah, Alan Jackson's amazing. You know, I know, rest in peace, Maggie and Paul. And I have a little clip that I made. I don't know if I can pull that up. Yeah, Abby, we did the most fun, incredible deep dive, in my opinion. Like, well, okay, I will say this. I've said this before. Many of you guys have heard me say this a million times. Murdaugh is my favorite trial, and I consider myself, if there's such thing exists, to be like a Murdaugh scholar. Obviously, you know, I keep saying that, but Need Some Z's is always weighing things out very logically. I love it. Shout out to you as well. Thank you for being here. But we did something really unique with that because, like, I knew I wanted to do this trial gavel to gavel, but there was also a lot of unanswered questions, and I love, how to say, like, going down squirrel holes, you know, like squirrel holes, like not wormholes or rabbit holes, but squirrel holes. And I love using logic and like critical thinking and like trying to solve things, like trying to find, like ask, like I love asking questions, even if you can't find the answer, but usually you learn things. And sometimes you might find an answer. So what we did was really unique for that, for the Murdaugh deep dive, the Murders trial series, because we watched the trial gavel to gavel, but all of everything that we watched, it was all videos I prepared ahead of time, which is what I'm doing for these other cases, unless it's live. Like, for example, tomorrow I'm going to be streaming Karen Reed live, so that's not going to be a video file. But, you know, for these recaps, it's all a prepared, you know, video file. But the difference was with Murdaugh, because the trial was over and because I'd studied the shit out of that for years. It was like gavel to gavel trial, but combo with like a deep dive combo. Like, I don't even know. It was kind of a unique format where, you know, when something would come up in testimony and we were watching everything in order, gavel to gavel, something would come up in testimony, then we would be able to go and do all the things with that, whether it was take a field trip to South Carolina, which we did a lot of, or pull up the other conflicting testimony, or we had the different series. We had What the Truck, we had chicken business adjacent. We deep dove the fuck out of that. And there were a lot of unanswered questions that some of them didn't need to be answered to prove guilt or innocence, obviously. But there were a lot of loops that were not exactly closed and things of that nature. And some people might be like, okay with just like accepting that. I'm not one of those people, but it was so incredible. And I feel like we all learned a lot and we exercised our brains a lot. And people were getting involved doing research. I think about it all the time, y'all. We're going to have to do it again at some point. And I guarantee you, we are going to discover new things. Even as closely as we watched it, I guarantee you we'll be like, how did we miss that? How did we miss that? How did we miss that? That's exactly it. We went down every avenue, including Murdaugh Avenue. Yep, accurate. That's right. We sure did. It was freaking amazing. Okay, Abby, glad. Yeah, drive safely. Hopefully we'll be here. I'm sure whenever you get where you're going, we'll be here. And I do have a beautiful little video for Maggie and Paul it's the very conclusion of the whole series. And so it's at the end of the very last episode, but I also made it into a shorter video I think it's just called Justice for Maggie and Paul. But like, it just has like the ending where he's like sentenced, but I have like a couple little things in there trying to make it like kind of special, but without saying anything. So that's something to like, for anyone who's thinking about them. But yeah, we went down every avenue, including Murdaugh Avenue. And I love that. And like, I want to continue that format. So it's not a format that can be done while a trial is happening, obviously, right? Like the Karen Reed trial or whatever. But after trial's over and you're not just trying to keep up, you know, like with real time and like you also have the full picture after it's over because you've heard all the testimony. So like whether it's with Karen Reed or any other trial, that's how I plan to do it. Is I plan to do it similarly to that, or like the same way, like where it's a gavel to gavel trial, but with all of the context, where we go do all of the backstory, we do all of the exploring, we go wherever our brains take us, and we learn everything, and we examine everything in a way that nobody else probably has done because we go a little bit overboard, but that's okay. That's being squirrely. So, all right, y'all, first things first, we're going to cover. So I mentioned the things with regarding this affidavit. I was thinking it would probably be a good time at some point to revisit it. And I have to say, big shout out to, oh crap, what was their name? Let me see if I can find their name. I have to give a shout out to somebody who's not here that I know of, but they might be here at some point. Let me find it. Althea on YouTube. Username Jelly Garcia. Shout out to you, my friend. I hope you're listening. Jelly Garcia was kind enough to point something out from part 1 of this hearing that I inadvertently talked over, which I try. You guys know how funny I am about that. Like, it might be one of the first times where I talked over something important and I didn't catch it and go back. Well, I don't know. Don't quote me on that, but I feel like I really try. But it was one of those times where I was answering a question or whatever, and I didn't see that this was coming. And I talked over something important. And so she was kind enough, let me share my screen. She was kind enough to point that out to me, bring it to my attention. And so immediately I was like, okay, let me go find it. And I found it. And then I was like, okay, you know what we need to actually do is we need to actually go back and do some of the affidavit because it's really relevant to the part that I accidentally talked over. And this should be able to show you my mouse as well. Great. Excellent. Okay. And so I went ahead and told them, I was like, thank you for letting me know. Like, all right, we're gonna hear that part again from the testimony. And then we're going to also do the part from the affidavit, and then we'll hear the argument. So part 1 for this, I think most of you guys have probably seen it, but it's in the playlist, and it was all the testimony from Brett Payne and from Cy Ray, who was the cell tower forensics expert. Brett Payne wrote the affidavit, the PCA, which all of you guys I'm sure are familiar with, but it might have been a while. I know it'd been a while for me. Brett Payne wrote that. So it was actually, that was why it was really significant to hear from him on Thursday, because that was the first time we've heard him testify like that and be questioned. So he was on the stand for like, I don't know, an hour maybe. And they went back and forth questioning between the defense and the prosecution. And in this case, the defense was direct examination because they were the moving party. But I explain all of that as well in part 1 of this hearing. So, so we're going to take a look because a part of what was discussed a great deal of in the hearing was, it's the things that the defense doesn't have. So among that, video surveillance footage, there's things that are missing in terms of how they saved their work, or rather didn't save their work for the cast draft report. Some other different things. And it was very informative. The testimony was really important and really interesting. And one of the things that Ann Taylor had been saying all along, and was still saying on Thursday, is there's things that they still don't, that they need, that they don't have, that are really quite kind of basic. And some of it is stuff that's like, how did they even figure him out as a suspect? And it's easy to kind of feel like maybe they're just saying that because of blah, blah, blah. However, when you listen to the testimony, and Need Some Z's was there the whole time, and actually, Need Some Z's, feel free to chime in, because she actually had listened to this before even we covered it. She listened to the hearing live that day, even though Chad and Karen were going on. She listened to it live and then also watched it with us. So, but yeah, so the Elantra, so part of it was, this whole thing with the Elantra, where I don't know if you all remember, but initially they were requesting, people that knew of Elantras from make and model, right? But then the year was like 2013 to 20, or was it 11 to 13? And then it was expanded from 2014 to 2016. So then you got a bigger range. The whole range was like 2011 to 2016. So they expanded that. And so she was asking about that. And a lot of Brett Payne's answers were, you're going to have to ask somebody else. You're going to have to ask somebody else. So he was the corporal detective And actually, she asked him, like, so would you say this is like the lead detective? And he was like, yeah, basically on the case. So he didn't, I will say he was not great on the stand, in my opinion. Maybe he'll do better for trial. I'm sure they didn't prep him for this because it was just a hearing. Hopefully his attitude was not, I don't think the jury will care for it. We've heard from a lot of law enforcement on all these trials, and yeah. So anyway, so here's the part of the affidavit I wanted to go over, because this has to do with the Elantra. And again, this is also shout out to my friend. I already, let me pull the name up again so I don't get it wrong. Tella Althea, username Jelly Garcia. Okay, so thank you so much. So, all right, so this is the PCA written by Brett Payne, who we heard from in part 1. All right. As part of the investigation, by the way, my cursor is going to read along for you guys here. So as part of the investigation, an extensive search commonly referred to in law enforcement as a, quote, video canvass, end quote, was conducted in the area of the King Road residence. This video canvass was to obtain any footage from the early morning hours of November 13th, 2022 in the area of the King Road residence and surrounding neighborhoods in an effort to locate the suspect or suspect vehicles traveling to or leaving from the King Road residence. This video canvas resulted in the collection of numerous surveillance videos in the area from both residential and business addresses. I have reviewed numerous videos that were collected and have had conversations with other Moscow Police Department officers, ISP detectives, and FBI agents that are, and I guess the ISP, that would be the Idaho State Police, right? And then the FBI, we know what that is, that are similarly reviewing footage that was obtained. A review of camera footage indicated that a white sedan, hereafter, quote, suspect vehicle 1, was observed traveling westbound in the 700 block of Indian Hills Drive in Moscow at approximately 3:26 a.m. Side note, we did a little mini field trip during the hearing and took a look at Indian Hills Drive. So you feel free to check that out. I believe I have it timestamped as well, where we did that. And westbound on Steiner Avenue at Idaho State Highway 95 in Moscow at approximately 3:28 a.m. On this video, it appeared suspect vehicle 1 was not displaying a front license plate, and we've heard that. A review of footage from multiple videos obtained from the King Road neighborhood showed multiple sightings of suspect vehicle 1, starting at 3:29 a.m. and ending at 4:20 a.m. These sightings show suspect vehicle 1 makes an initial 3 passes by the 1122 King Road residence and then leave via Willenta Drive. We also took a look at that area as well on the last episode. Based off of my experience as a patrol officer, this is a residential neighborhood with a very limited number of vehicles that travel in that area during the early morning hours. Upon review of the video, there are only a few cars that enter and exit this area during this time frame. So you can see here, if you're a defense attorney, you're probably already thinking, well, of the video, which video? And also that's where it matters. Did you get all the videos, right? Little reminder for anyone who has not seen part 1 or the previous hearing. Be prepared to be shocked. Hope you're sitting down. The Idaho Department of Transportation does not save their video surveillance of all of their roads. So all of your highways, your public roads, whatnot, stop lights, stop signs, public roads, that type of thing. They don't save it. So that's not, obviously that's not law enforcement's fault. That's just fault. That's problem. So there's plenty of video that needs to be had for justice. Like, it doesn't matter if you're the prosecution, like, it's just insane to me that does not exist. So that limits very greatly the video options, right? Because most of the video now that they're relying on came from private residences or private businesses. All right, so he says there are very few cars based on the video he saw, right? All right, onward. Suspect vehicle 1 can be seen entering the area a 4th time. Oh, he's missing a T. Don't worry, Brett. Shall I be cheeky and actually edit it? Cheeky squirrel. Will let me do a T here? Hold on. I know this font is Times New Roman. I might have to. Oh, what is it? Why? Why is it? Why? Okay. Maybe I'm getting a little bit too carried away. I know that with other the other PDFs I have, I guess it's Firefox versus Chrome. It's doing this weird thing. All right. Well, if it was in Firefox, which is what I usually use, I could do a T there. Never mind. We are going to, oh, this is why, I think, right? Okay, I don't know. I give up. We are going to edit that in our hearts and spell check that for you, Brett Payne. All right. So at approximately 4:04 a.m., it can be seen driving eastbound on King Road, stopping and turning around in front of 500 Queen Road, number 52, and then driving back westbound on King Road. When suspect vehicle 1 is in front of the King Road residence, it appeared to unsuccessfully attempt to park or turn around in the road. On the road again, the vehicle then continued to the intersection of Queen Road and King Road, where it can be seen completing a 3-point turn and then driving eastbound again down Queen Road. So some of this, whenever they talk about the Elantra drive footage, we've all seen this. I would imagine you guys have, but that's the footage where you can actually see the little U-turn with the White Elantra. Suspect vehicle 1 is next seen departing the area of the King Road residence at approximately 4:20 a.m. at a high rate of speed. I want to know which video that is. I would love to see that footage. I mean, obviously, I'm just saying, I know trial, right? But we have not seen that high rate of speed part. I would be curious. Suspect vehicle 1 is next observed traveling southbound on Elantra Drive. Based on my knowledge of the area, in review of the camera footage, he's missing the word the. I edited that for him again. Of the camera footage in the neighborhood that does not show suspect vehicle 1 during that time frame, I believe that suspect vehicle 1 likely exited the neighborhood at Palouse River Drive and Conestoga Drive. So in other words, entered a one-way. Abby, thank you so much for the super. Is it a super? I feel like Joel. Is it a super chat or a super sticker? Either way, thank you. That was very generous. You didn't have to do that, but thank you. I feel like Joel. I can see how he gets confused. I will just say this real quick. I think on StreamYard, I used to think that was a little silly because it looks really obvious on YouTube. On StreamYard, it's a little different. And that might be part of the confusion because I'm very well versed, obviously, with this stuff on YouTube. But I'm wondering if part of that is because on StreamYard, it's not as easy to tell. But thank you, Abby. I appreciate that. So he entered one way and left another way, according to this affidavit. Conestoga Drive. Not to be, my brain wants to say Constantinople, but that's a different word. Palouse River Drive is at the southern edge of Moscow and proceeds into Whitman County, Washington. Whitman. Eventually, the road leads to Pullman, Washington. Pullman, Washington is approximately 10 miles from Moscow, Idaho. Both Pullman and Moscow are small college towns, and people commonly travel back and forth. I don't know why you need to add that part, but having said that, let's just say something real quick using our brains. If indeed you are the state of Idaho or the state of Washington, actually, we can't say that Washington fucked up. So let's leave Washington out of it at this juncture. However, Idaho, put your ears on, Idaho. When you've got a sentence like this, Pullman and Moscow are small college towns and people commonly travel back and forth between them. The key part being people commonly travel back and forth between them. You know what you guys should be thinking about potentially is saving your video surveillance. So we can see the people that are traveling back and forth if indeed we need to. Idaho, are you listening? I just picture a potato with headphones on. Law enforcement officers provided video footage of suspect vehicle 1 to forensic examiners with the FBI. Oh, that's funny. It's spelled out here. Wow, that's weird. You never see that. It's always the acronym. That regularly utilize surveillance footage to identify the year, make, and model. Okay, now this is the really key part. Year, make, and model of an unknown vehicle that is observed, and this is discussed right in the hearing, in the testimony. An unknown vehicle that is observed by one or more cameras during the commission of a criminal offense. The forensic examiner has approximately 35 years law enforcement experience. So you can bet we're going to be hearing from this individual at trial, and maybe even before that in hearing. 35 years law enforcement experience with 12 years at the FBI. His specific training includes identifying unique characteristics of vehicles, and he uses a database that gives visual clues of vehicles across states to identify differences between vehicles. Now, I mentioned this during the hearing because I was like, well, listening to the way Brett Payne describes it, it's interesting because it's so this dude's yep, here's the years. It's a 2011 and 2013. Here you go. And then he comes back later. Is actually, it could be 2014, 2016. So it's I was saying it at the time, I could see why Ann Taylor's asking about it because it's either if you're the defense, think about it. Either it's like, well, clearly this dude isn't as great as he's made out to be, this dude, right? Because clearly he got it wrong. Like either he's second guessing himself, or there's some other reason. Let me know in the chat if you guys can think of other, like, what else could there be besides the, like, either this guy made a mistake or something else, because why else would he change it? Or, you know, like it's because it was like issued, like the search was issued for like that year, and then it was a second thing, you know? All right, so his specific training includes identifying unique characteristics of vehicles and uses a database that gives visual clues of vehicles across states to identify differences between vehicles. Copper, you guys, stop being so generous. But I appreciate you guys. I think I love y'all. Thank you. You don't have to do it, but thank you. So this I know is a super chat because of the chat part. Abby, you're so welcome. I'm so happy that you're here. And yeah, by the way, guys, so for anyone who's listening now, whether you're new here or replay crew, I do very detailed timestamps. In fact, I've sort of made it a thing. I don't know if you guys ever even look at the full descriptions, but I've gotten to the point where now it's like there's like inside jokes that get timestamped. Candace, actually, you got a shout. Did you see from, when was it? Actually, I forgot to mention this to you, Candace, if you're still listening, but there was something specific that you got a timestamp for in a recent video. So anyway, but like, yeah, very specific things, inside jokes that we have. Also, I've gotten to the point where I try to come up with funny titles where that is applicable. So like, especially with like Brian Higgins, there's some really funny, I've just, I don't know, I've gotten really creative with it, but also they're very specific. So anyone who's watching on Replay Crew, I just know that I appreciate good timestamps. And I think that even though there's really maybe not that much of a purpose to a timestamp that might be funny or like an inside joke, I know that it would make me chuckle and brighten my day. So, you know, anyway, like for example, on the video from, God, was it yesterday? All the days. The last recap we did with Karen Reed, I have a timestamp on there that from the beginning of the video, we were just talking about Trooper Proctor, or if you're Jen McCabe, Proctor Trooper. Trooper Proctor, Proctor Trooper, Trooper Proctor. She goes back and forth. I have a timestamp that's like, who, if anyone, will call Trooper Proctor to take the stand? Because it's making fun of Lolly, stuff like that. But all the timestamps will be done for this video as well after the fact. And for anyone who's on Replay Crew, it'll make it easier for y'all. Love you guys. Happy so much you guys are all here. Oh, and I forgot to do Copper's thing. Copper, there's your thing. We love you. So, and Abby, did you think of a command for yourself yet, my friend? So yes. Alrighty. So we did this sentence. All right. After reviewing the numerous observations of suspect vehicle 1, the forensic examiner initially believed that suspect vehicle 1 was a I was just saying this. That's funny. 2011 and 2013 Hyundai Elantra. Upon further review, sometimes I'll do funny accents as well. He indicated it could also be a 2011 to 2016 Hyundai Elantra. As a result, investigators have been reviewing information on persons in possession of a vehicle that is and actually, if y'all want to say vehicle the way that law enforcement says it, they usually say vehicle. It's funny. A 2011 to 2016 white Hyundai Elantra. All right, here's some more stuff. Investigators were given access to video footage on the Washington State University campus located in Pullman, Washington. A review of that video indicated that at approximately 2:44 a.m. on November 13th, 2022, a white sedan, which was consistent with the description of the white Elantra, known as, see, if I'm the defense, I'm already like, which one, yo? Like, yo, which one? Already, I'm like, okay, is this based on the first thing or the second thing? Are you saying this is from this year? I'm highlighting it with my cursor, 2011 to 2013, or is this in the expanded group, right? And I can see why she's asking this, because think about it, guys. Part of the thought would be, well, if they did it backwards, and we know this is not how it should be done. We know that you let the investigation lead you where you need to be, according to Phil Waters, right? So you don't find a suspect and then view the evidence through that lens. So I think part of the issue is like, well, did they see this car here on Washington State University campus and realized it was in a year later than 2013. And then is that when they updated that thing, right? You see how I think that's part of the concern that Ann Taylor has. Understandably so. If you're a defense attorney, you have to look at all that. So yes, so they were given access to the video footage, and right, we read this. So the white sedan, but what's interesting here is it doesn't say, okay. And I want to know the timing. See, already I'm thinking like a defense attorney. I want to know the timing. So we know, like, this is all, see, and in my mind, I'm like, why don't we have more information? Because here's the thing. We need to know, here's what he says in here. He says, initially believed. There's no time, there's no date. I want to know when specifically, time, date, this happened. When it came out, they came out and said they're looking for 20, because I remember this, guys. Do y'all remember this? They said 2011 to 2013. I feel like it was several days later, maybe a week later. There was a period of time before they changed it. I remember that very well. Do you guys remember? I would want to know exactly the time and date for this one, 2011 to 2013, and the time and date for when it got changed. And then I would want to know the time and date further for this part that I'm highlighting, the video footage with Washington State University. When did they find this with the 2:44 a.m. white sedan? Was that when in the process of all this changing of the years was that found? If you're a defense attorney, you need to know that, and you need those videos, and you need all this information. And I feel like it should be in here, right? I feel like it should be in here. Like, why, like, I don't know. Yes, Abby, you have got it. Hold on. Are we talking about ice cream again? That's right. I did timestamp the sex ice cream. You saw that. Yes. Oh, y'all, for anyone who missed it, we had the best time that night. We were talking about sex flavored ice cream, right? That's a new thing that we made up. Like, if with such a thing as sex flavored ice cream, what would that ice cream taste like? And it was so funny because Super Planet Girl gave this description that was so cute. It was like lavender and salted caramel. And then I made a joke. I was like, I feel like the way you can tell a lot about how people's sex life, by the way, they answer this question. A lot of really funny answers. It was great. So yes, let me do Abby's command. I'm going to make the command. Let me do it on my phone because that'll be easier. I'm going to make the command ! Abby. So we're just going to multitask a little bit. I have Nightbot saved on my phone for the link because I Nightbot all day, every day, basically. Love you, Nightbot. We love you. This will only take me a second because I make commands so often. This will be done in just a second. Okay, let me find the right emojis here. I've got the cat smiley face. Okay, now these appear a little bit different on StreamYard than they do elsewhere. So hopefully I find the right. Let me know if these emojis are not the correct ones because I have to guess because they show up differently on StreamYard. For anyone who didn't know that, it's interesting that emojis show up different on StreamYard than they do everywhere else. They look the same. So that face, the smiley face, what type of emoji would you guys call that? Because it's going to be a harder one to match based on, is that like it's like a side smile. Sometimes the emojis actually differ very greatly, which is interesting. A smirk. Okay, let me type smirk and see if that. Aha, got it. Got it. Thank you, Abby. That helped. Because it knew smirk. I found it with smirk. That worked. Oh my God. The smirk worked, you guys. Insanity. Okay. All right. I'm submitting it. So now someone do ! Abby. And Abby, let us know if we got that right. Need some Z's. It changed around December 19th, 20th. Yes, but we need to know when they found this video from Washington. Like, we need to know all the other stuff for that to, sex flavored beef jerky. You can have whatever you want here, guys. I'm here to make your dreams come true. So you can have all the sex flavored jerky you want here. Also, one of the Desert Island questions we asked last time was if you could choose between Flying, and then Super Planet Girl, we kind of expanded that to teleporting, which is like flying but without heights for people that are scared of heights. Versus time travel. And then I made it very clear the teleporting in this case does not include time travel. It's not cheating. You get one or the other. Flying. See, for me, it would be flying because I would want to fly, but I would actually pick time travel. But flying / teleporting, you get your choice between those two versus time travel. Right? That's okay, Blackwater. Tell your godchild we say hi if they are still there. Did anybody try Abby's command? Neeson Z's would choose teleporting. Wow, I'm the only one who chose time travel. I should be clear. I don't even mean time travel in the future, although for the sake of the question, it could mean that. But in my mind, I only considered back in time because that's what I would do. I would have no desire to go, oh my God, I forgot we have another app. Oh shit, that's the problem. Hold on, guys. Sorry. We have more than one Abby command. Oh wait, also I spelled Abby with an ABBT because I can't type. We've got some issues here. Hold on, let me fix this. Okay, it's Abby X. Oh my God. Wow. Sorry, I can't type. Abby X. If someone wants to try it. My goodness me. Exclamation point Abby X. Okay. Let's see if that worked. Yeah. So that command, I forgot because we haven't seen other Abby in a while. So yes, it is Abby X. It should be there. But yes, I would choose time travel, but I would only even have the inclination to go back in time. So oh, I hope I'm sure that's so cute in a way. Okay, is this right, Abby? Did we get it? Okay, good. Glad he's 21. Godchild. Yeah, can be misleading. Excellent. So the cat face is the right cat face. All right, cool. Excellente. All right, so I just thought of a song. What was the song I was thinking of? I lost it. It was something that had to do with sex. Okay. All right, so we just read this part. The white sedan, which was consistent with the description of the White Elantra, known as Suspect Vehicle 1, observed on the campus. Right, we got all that. Nevada Street in Stadium Way at approximately 2:53 a.m. A white sedan, which is consistent with the description of the White Elantra, known as Suspect Vehicle 1, was observed traveling southeast on Nevada Street in Pullman. So did he sit in the car for a while? I wonder how far that is because we know it's not that far of a drive period to get between the two places. So at 2:44, he's on the WSU campus. He's on Nevada Street, southeast. But then at 2:53, he's still on Southeast Nevada Street. It doesn't say he's still on campus, but in other words, that's 9 minutes, but he's on the same road. Maybe it's a long road. If anyone wants to Google Maps this situation, I would, but I'm going to try to keep reading before I lose my spot again. But I'm curious, it could just be that it's a long street, or was he sitting in his vehicle for a long time? See, these are the questions that pop into my mind. Towards what the heck is that? SR 270. Is that a road? Oh, state road. Interesting. Huh. We do not have road names that look like that here in North Carolina. State Road 270 connects Pullman, Washington, and Moscow, Idaho. This camera footage from Pullman, Washington was provided to the same FBI forensic examiner. Aha! Okay, so again, we don't have a time and date, but we do have a precipitating event for when he changed the year. The forensic examiner identified the vehicle observed in Pullman. Interesting. I see why she's like, hey now. I see why she's saying that. That makes perfect sense. Because here's what they're saying. They're saying that they had this video with him on campus or with a vehicle on campus, right? They can't see who's in the car ostensibly, right? They see the vehicle, the way they say it in law enforcement. Gotta be fancy sometimes. They have that footage, and that footage is what they used to identify at 2011 and 2013. And then different footage, which is on State Road 270. which either must have been provided either by Washington or by a private business because Idaho doesn't have it. But after that footage, they reassessed and changed the year to 24. So you know what's interesting? Here's the thing, guys. They didn't change it by updating it and saying 2011 to 2016. This is what's interesting. I guess they can only give like a certain period window of 2 years at a time. So they had to update it by saying 2014 to 20. That's even more interesting, right? So in other words, it's not like it was initially 2011 to 2013, and then they were like, well, we're going to just extend that to 2016. The way they have to do it is they had to say, okay, it was 2011 to 2013. And then when they decided it could have been a different year, they had to come back and make the year different and say 2014, 20. So that's completely different. In other words, this second one that I'm highlighting, when you look at the way that reads, that's saying it is not a 2011 to 2013, right? Because those years are not included. But then they came back later and then they just combined the two, smushed them together. At approximately 5:25, a white sedan, which was consistent with the description of suspect vehicle 1. But which suspect vehicle 1, though? Because it's like on which camera footage? Because like they're different. Anyway, was observed on 5 cameras in Pullman, Washington on WSU campus cameras. I want to know which year was observed in which footage. Some of this stuff we're probably not going to learn until trial. I'm really curious. The first camera that recorded the white sedan was located at 1300 Johnson Road in Pullman. The white sedan was observed traveling northbound on Johnson Road. Johnson Road. I guess this is when he's going to like, or where is he going? I know at some point he goes to that, to like, what grocery? He goes to the grocery store or something. I can't remember. Whole Foods, maybe? Okay, so this is just more about the times and him driving. Okay, here's a depiction. Okay, now what's really funny is in the hearing, y'all, I don't know if you guys remember, but in the hearing, I pointed it out because I thought it was funny, but now we get to see the map. That's funny. I didn't know it was the same map. So in the hearing, there's a part where Ann Taylor goes up to Brett Payne and she's like, okay, are you familiar with this map? And she hands him a map and we don't know what it is because we can't see it. But it's this, and now I understand it's this map from the affidavit, which makes sense because he wrote this affidavit. This is the fucking map. Incredible. Now I know why she did this. And she did this so freaking well. Oh my God. Instead of being like, so why did you give me a shitty ass map? What she did was she was like, they were already doing their questioning. She goes, okay, are you familiar with this map? And she hands him an exhibit and it's this piece of shit map. And he goes, I don't know. It's kind of hard to tell. And she was like, she said something like, yeah, it's hard to see, isn't it? But she did it in such a way. I was like, that was brilliant. Yeah, this is pointless. Why even include this? This is an absolutely useless map. Holy crap. Wow. You can't even make out. Let me zoom in more. You can't even make out. What? Why even? What? It's a joke map, guys. It's a joke. Oh my God. Why are we doing that? Okay. Hold on. By the way, that was Frodo, if you saw my screen. This is the map. You've got to be kidding me. I'm surprised she was that nice about it. Holy mackerel. She could have been a lot snarkier. That's insane that you do. Like how? I'm sorry. How is this though? How's this? Like, is it a joke? Is it a joke? It's got to be a joke, right? Look, because if you read the words are misleading. The words say depiction showing Moscow and Pullman. I would disagree and say this shows literally nothing. Perhaps it is the most useless map of all time. Like literally, you can't make out the numbers. This is the exact exhibit she had. It would have been printed off. Holy mackerel. Wow. I don't even understand that at all of how this even makes it into a thing. If you were in first grade and you were doing a project for school and they were like, okay, include a map picture, and you turned this in, the teacher would be like, you would not get a check mark and you would have to redo the assignment. Like, just saying. That's just facts, guys. Yeah, they're saying, I heard, what did I hear? I heard recently March 2024 is what I heard most recently. Initially, there was talk of summer, but now I'm hearing March. Oh, I see your question now. So Sarah Penny Girl says, I'm glad I thought of teleport. The only reason I picked time travel is right. Why does nobody want to do time traveling, y'all? Oh, I see. Potentially be upsetting. You guys, I just want to go back to Tudor England. I mean, it's that simple. And I want to meet Bob. That's why. Otherwise, I'd probably pick flying. Yeah. So I heard rumblings of March 2024, which is better than summer because it's less than a year away instead of more than a year away. Oh my God, that's hilarious. Abby, you get 5 points. Sometimes we do this game like in Whose Line Is It Anyway, where it's like, you know, they have that slogan and it's like something, 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 and the points don't matter. And we never know the beginning of the slogan. And so every time it's just like that. We're like that. We're like something, 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 and the points don't matter, but you get 5 points. That's freaking amazing. Well done. Well done. Yeah. You know what? Yeah. Excellent. I love it. I love it. That was good. Yeah, luckily, I think you're all good without the tagging officially because there's not that many people. Okay, thank you for the question, Abby. What's my opinion of the prosecution team in this case so far? I will say that I am far more impressed by the defense attorneys in this case so far in terms of the lawyering. That has nothing to do by which I mean I'm talking about their argument, the hearings. I'm not talking about the quality of the evidence. That to me, that's a whole different thing. Like the quality of the evidence is like law enforcement investigation, right? So I'm taking this question the way that you worded it. I believe your intention is the lawyering, which to me is a whole thing. So going by the lawyering, again, this is just the lawyering. This is not the quality of evidence. This is not guilt or innocence. This is the lawyering. Of course, we can't decide guilt or innocence anyway. But I would say the defense team is outstanding. Ann Taylor is a force. She's again, I aspire to be like her and that attorney whose name I don't know from that thing I was watching this morning. And like aspirational people, in my opinion, because it's got to be hard to have so much compassion. And boy, can I tell you again, I already said it, but like I think we all could stand to try to be a little more like that. It takes a bigger and it takes a greater person than I, you know, like, but I want to be that way where I cannot assume guilt, where I can, you know, and I'm not saying I assume guilt. I think that I don't, but like, I still feel like it would be a little bit difficult for me to have, you know, she treats him like, I'm sure she treats all her defendants like this, you know, like they're her family member. I mean, with so much love and compassion. And it's just, and the way she even gestures to him, and I pointed it out in other hearings, but she gestures to him, she like puts her hand on his shoulder and there's like, I don't know, man, it gives me goosebumps. That's all I can say. World could use more of it. Yeah. Yeah. Anna's defense. Yes. She's the lead defense attorney and she is court appointed, right? So she's a public defender. She's a public defender. And so far, I would say she's already easily, in my opinion, doing some of the best. Like, I think she's incredible. Like, we see people all the time pay money for attorneys, for defense attorneys that couldn't even aren't even in the same category. Look at, no offense to any of these people, Dan Rashbaum, look at John Pryor, the list could go on and on, right? She's in my mind, when I think of like some of the best defense attorneys I've ever seen. All right, we got Mark Eiglarsh. Y'all know how I love him from when we did the Saturday Night Special. Great opening statements. Mark Eiglarsh. I'm going to give you 4 of my favorites that I can think of right now, but this would probably be pretty conclusive. Mark Eiglarsh, David Yannetti, Alan Jackson, Ann Thompson. Ann Taylor. Why did I just say Thompson? Ann Taylor. Bill Thompson's the prosecutor. Holy shit. Ann Taylor. And of those 4, one of them is a public defender and the rest maybe have been, but are currently not. Right? You have to hire them. So, but she is just as good as those. I mean, she is incredible. She's incredible. I love her. Like, Ann Taylor, I love you. Not in a creepy way. Not in a creepy way. If I ever get into a bind, I'm going to try to see if I can get you to come and defend me. Hopefully that never happens. Yes, 2025. Did I say 2024? I probably did. Right. Because there was a time when we added the year 2024 to the end of this when talking about this trial, didn't we? I meant 2025. Thank you. Yes, indeedly do. Yes, and that reminds me, I need to check my mail. I'm just remembering that Super Planner Girl mentioned something about a letter. I need to check my mail. Thank you for reminding me, Super Planner Girl. She has tenacity and she's very smart. She's a smart legal mind. Yeah. Now, here's the thing. I think they have good evidence. They're the DNA. It's like, for me, it's like the DNA on the knife sheath, because the thing about that's going to be really hard to get around. They're lucky they have that. Like, that's the thing. That's the thing. That's the thing. I think that, and the part of the reason why I love great defense attorneys like Ann Taylor is because it would be, you could have a situation wherein when you have evidence like that, such as DNA on the knife sheath, you could imagine a situation where potentially the prosecution feels like they don't need to try that hard. I'm not saying that's happening or whatever, but I know that is part of what, you know what I mean? Like, they might not have to fight that hard or whatever. And the reason I love great defense attorneys like Ann Taylor, she's going to make them fight every step of the way. And that's how it should be. That's how it should be. We do not want lazy government charging people with things and prosecuting them. Nope. Sure don't. I'm so happy to hear that. So Super Planner Girl, for anyone who hasn't heard, she sat on a jury. I can't recall what year that was, but she sat on a jury, and I love hearing about that. But I'm so happy that you are saying this as well, that you were shocked by the amount of care. That's awesome. Oh, wait, hold on. Did I miss something? Hold on. What did I miss? What did I miss? Could have been anything. Yeah, I assumed you meant A-N-N-E. I don't know if, anyway, hopefully I didn't get anything mixed up. Bravo. Well done. Well done. Yes. That's so funny, right? I've never been in an Ann Taylor store, but do they have power suits there? That would be freaking amazing. Holy crap. Black Widow is singing. That's so cute. Hey, have any of you guys, I think probably all of you guys have seen the music video. Abby Crossing, have you seen the music video for the Karen Reed trial? Okay. I love that you guys are getting confused, even though there's not that many of you guys here. That is so cute. I love that so much. I love it so much. I love, love, love. Look up Ann Taylor. Do it. The store usually has the word loft at the end, I believe. Like, if you do a Google search for Ann Taylor, you're going to get stuff with this shit about the store. But if you want the attorney, you just have to, like, type in attorney at the end. And usually Idaho. And then you might find her. At this point, my Google algorithm thingies know I'm looking up the person. So it doesn't suggest the store anymore. Okay, so now are we going to have another shitty map? Depiction showing White Elantra's path of travel, not to scale. You're joking me, you guys. Pardon me? Pardon? Path of travel? Pardon? Come again? Wow. I can't even imagine I cannot imagine. I can't imagine being a defense attorney on this case when you first get assigned and you're just looking over the affidavit, which would be the first thing you do, and you see this. I would be like, am I being punked? This is insane. Oh, I can do that song, by the way. I love Simon and Garfunkel. Hold on. And you shall receive, guys. Hold on. I don't know what made you think of Simon and Garfunkel, but you know what? We love Simon and Garfunkel. I grew up with my mom, by the way, Schmammers, who's probably not here anymore, but we used to do a lot of songs together with guitar. She also plays guitar and sings. We did a lot of Simon and Garfunkel and Joni Mitchell. In fact, I'm named after the song Chelsea Morning by Joni Mitchell. Well, I don't really care if it's perfect too, because I'm just going to do the little bit. We'll see. Do I need a capo? It's going to bother me. It's out of tune. Okay, hold on. Okay, let me change. Let me just tune this. Let's see. What finger picking pattern did we do? I haven't played this song in forever. Let's see, do I want third? No, we need something else. Maybe I'll just go with that for now. Are you? Oh wait, this is not a good key. Hold on, let me check the capo on. 2 seconds. Also, I've noticed sometimes my computer can't handle my voice because I sing really loud. So if the microphone does that weird thing, I'm sorry. I'm gonna stand back because hopefully it won't clip. I think sometimes it clips when I sing. Let me add another capo or move up a fret. Okay, that's better. That's better. Capo on fret 4 for anyone who's playing along. Not that anyone is. All right. Are you going to go? Right, wrong chord. Hold on. Okay, it's G major. Hold on, let me try it again. Are you going to Scarborough Fair? Wait, parsley. All right, walk down there. Okay, hold on. Parsley, sage, rosemary, and thyme. Hey, I can do better than that. Hold on. Parsley, sage, rosemary, and thyme. Remember me to one who lives there. But she once was a true love of mine. Tell her to wear a cambric shirt. Parsley, sage, rosemary, and thyme. Without no seams or needlework. Then she'll be a true love of mine. What's the next verse? Tell her to something, 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 and then gathered all in a bunch of heather. I can't remember all the verses. I can also do Sound of Silence. Let's see. Yeah, this one actually was maybe better without. What am I doing? Hold on. We're supposed to be doing Moscow, Idaho. BK. That's work. All right. Guitar goes away. Sorry, packing up my guitar. All right. I love Simon and Garfunkel. You guys, stop sending me more things, y'all. You're welcome for welcoming you. So that was just anytime, y'all. I'm gonna say this for reals. Y'all, anytime you want to like any Simon and Garfunkel, Joni Mitchell, like Bob Dylan, anything from the 60s, y'all can request it anytime. I can play any of those songs by ear. Probably just I might only know one verse, but you know what? Like, yeah. These maps should be in MoMA. I know this is an atrocity, right? Like, sorry, this map should be put on trial. Like, get this map a public defender, please. But it doesn't even deserve someone as good as Ann Taylor. Like, even Ann Taylor, like, hold on. I can do better than that. Even Ann Taylor could not defend this map. That's it. That's the one. Yeah, it's the anti-map. Exactly. Candace, did you hear what I was saying earlier that you have a timestamp specific to you in one of the recent live streams? I couldn't tell you which one because there's so many these days. But hopefully you saw it. It was a specific Candace specific shout out timestamp thing because there was something that happened that was relevant to your command here. But I'm so happy you're here, Abby, and I hope you have a safe drive. Yes, I sang that one though. Camera sure without no seams or need to work. So you know the song too. My mom would always be the one in the background singing like the part that's like the B part. She's like, "If sleeps unaware of the clarion call," that part. And I used to always yell at her because she wouldn't get her entrance right. Y'all, I've got some funny stories about this. All right, first story. These are quick. When I was 3 years old and I started violin, my mom would be my accompanist on piano. And I mean, I like forced her to or whatever, right? I mean, she wanted to. Okay. And so because like with Suzuki violin, it's like you can have people accompany you and stuff. So she would play the piano part. And whenever she'll tell you this, guys, you can ask her. Whenever she would make a mistake, apparently I would like yell at her. And then actually one day when I was like 3 years old, I fired her as my accompanist because she made too many mistakes. Oh. And I'm like, I mean, I don't remember that specifically, but I kind of remember it. And I'm not surprised. Like, I believe that. And then also when we did our guitar songs together, like with that, because she has, like I said, she plays guitar and sings also. Whenever she would get that, those entrances are tricky. However, we've been playing that song for years. And whenever she would get those entrances wrong, I was like, she would see it coming too. Y'all, it's like she would start to make her entrance and she would already know it was going to be wrong. And she would already know I was going to stop and yell at her. So she would just like stop playing ahead of time just to save ourselves the trouble. Yell at her for getting her entrance wrong. I know it. I agree. Exactly. It's not funny, but it's so bad. All you can do is laugh at it. But it's horrific. It's horrific. It's horrific that this is in an affidavit. But what else can you do but laugh? I mean, like, honestly, I just appreciate, I want to actually find it now where Ann Taylor points this out on the map because it's honestly, I appreciate it even more. Like at the time I commented on it and I was like, wow, I love her demeanor there. Like she totally did a great job pointing that out to him, but like she was really polite about it. Like, but it was also kind of funny. Like you could tell there was a little bit of like that she was like, yeah, obviously these maps are terrible. I don't know. But I didn't realize I didn't see these. Like I didn't know it was these, but that anyway, I just appreciate it. Well, that is very lucky for Johnny, right? I guess I probably shouldn't be saying his name. No, sorry. I know it's not Johnny, it's Andrew. I shouldn't be saying his name, sorry. But not like anybody's gonna know how and where to whatever. Oh, Candace, when I was 17, a boy played guitar and sang Scarborough Fair to me. Oh my God, so romantic. I hope you had a crush on him after that. That is so cute. I love that. He must have been a good one too if he knew Simon and Garfunkel. Yeah, I mean, as you guys have heard me do, like, learning the music by ear, I can play any song, like, on any instrument at any time pretty much, like, if I've heard it before. So, like, that same is true for violence. Like, any it doesn't, like, in other words, I don't have to know the song. Like, you guys have heard me do this live before. So, like, even if it's not Simon and Garfunkel or Joni Mitchell, like, if you guys ever have a request, just, like, let me know. And also if there's songs that are relevant. I just have to make sure my guitar's in the right tuning because here's the thing. Most regular songs are going to use standard tuning, but the songs that I write, most of them don't use standard tuning. So luckily, I'll just say my guitar is in standard tuning because I had to put it in standard tuning to make the music video for Get Low, Canton style. It was not in standard tuning. I put it in standard tuning for that and it's still in standard tuning. So now's the time because it's in standard tuning so I can easily play other songs. Oh my God, you guys got engaged? Holy crap. Happy to see you. ABC Stock, it's happy to see you again. Glad you're listening. Hope you get your cleaning done. Ah, yes. So you got engaged. I wonder what became of him. You don't have to share your whole life story, Candace, but y'all know I'm very inquisitive. I wouldn't even say nosy, but I'm very inquisitive and I love learning things about people and everything. Like literally there's no topic that I would not want to learn about. Hold on. I feel like there's going to be an exception. I feel like there is an exception, but I'm trying to remember what it is. I will say though that Lolly like Lolly could be talking about violence and I would still be like, oh my God, stop talking. So there's that. Okay, so these maps are an atrocity. We've got that part covered. On November 25th, all right, so here's some more shit on the Elantras. MPD asked area law enforcement agencies to be on the lookout for the white Honda Elantras in the area. On November 29th, 2022, at approximately 12:30 a.m., police officer Daniel Kingo carried White Elantras, registered at WSU. I don't know if that's how you say his name. As a result of that query, he located a 20. That answers. Remember when I was like, I wonder if they had him on the mind first and then at. So look, check it out. So his year was 2015. All right. I think we knew that, but I forgot that. Now I'm remembering. I was lost, but now I'm found. I was blind, but now I see. What is happening? Which is interesting, right? Good thing they updated that year, right? If you're the defense, you're like, I don't know about all this. Which sometimes things aren't fishy, right? Like, you just have to have all the information, and that's why you get all the information. It makes perfect sense. The vehicle was registered to BK, etc., etc. Cougar Way. Sorry, my brain. That same day at approximately 12:58 a.m., WSU officer was looking for white Hyundai Elantras and located 2015 white Hyundai Elantra. Okay, this might be the end of the portion that's relevant to the part we're going to watch that deals with identification of the vehicle. I still would like to actually read over this whole thing. Let me know, you guys, if you're interested in that. I know that this has been covered extensively, but I feel like it's been a long time because this was covered extensively when it came out, which was a long time ago. And also, justice with Murdaugh, justice with every other trial, right? It's like for example, okay, because as we learn more things, previous things make more sense. So, for example, this business with the Elantra, I would not have even noticed that or paid. I don't know. It wouldn't have had significance to me in the same way were it not for what came out in this hearing. And so, sometimes you don't know what's important until you know what's important. Am I right? So that's what I'm saying. Yeah, Candace, we love you. We will all marry you in a heartbeat. Just let us know. We will all marry you in a heartbeat. So the fact, you guys, you know what this reminds me of? I was in my heart, I was like, something reminds me of this, but I couldn't think of what. You know what this reminds me of? Where it says depiction showing White Elantra's path of travel, not CL. This reminds me of the Solo Cups with Runkle when he makes the joke and he's like, why did they wear the gloves? He's like, they did everything else wrong. It's contaminated in every way possible, but we're going to put the gloves on. And he makes the joke about the gloves. It's like, why bother? That's how I feel about this. The part where it's not to scale. Is this a joke on top of a joke? Is this joke inception? Because what's even the point of any? Is this joking? I just can't. It's so funny. It's so funny and so horrifying. Yeah, she's got Andrew, as they say, fucking Andrew. Okay, so now we're going to jump into the video real quick. Let me get my mouse onto the thing. And what we're gonna do, he's not home yet, is under the sea, under the sea, under the sea, under the sea. Doon, 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 doon. All right. So first, what we're going to do, like I said, we're going to hear just this tiny little snippet of the testimony from part one. And it's going to be the part about the Elantra that was, again, pointed out to me, thankfully, that I was talking over, though I try not to. And we missed something important regarding the Elantra and the surveillance and all this stuff that we just talked about. And remember, that affidavit was from Brett Payne, and we're going to hear now from, guess who? Brett Payne himself. The man, the myth, and the legend? No.
I want to talk a little bit more about the video and what's been turned over and what hasn't been turned over to us. And I want to focus a little bit on South US 95. Do you recall that south of Moscow on US 95 is the path that you put in your search warrant and affidavit alleging that Bryan Kohberger left Moscow going south on US 95?
Yes, ma'am.
All right. And are you aware that one of the videos that you gave us, the coffee shop there on South 95, that leaving Moscow, you'd have to pass that covers 5 a.m. to 6 a.m.
I do not recall the time frame for that.
And so the time frame in these videos would matter, right?
Certainly.
The time frame in the videos to be meaningful would need to cover a time that surrounds the allegations against Mr. Kohberger. Is that fair to say?
You could say that, yes.
Okay. And are you aware that Watson Kari Construction had a video, and that also has a very limited time frame, like 5 a.m., just 1 hour of video also?
Sounds vaguely familiar, yes.
And that's also south on Highway 95. Is that right?
Yes, ma'am.
And the one we talked about today, Monday's machine that nobody could find, that clearly was given to Moscow Police Department, that's also south on 95.
Yes, ma'am.
Okay.
So I'm going to pause it, not to talk over. So she's saying, so we actually took a look. I believe I also timestamped it from part 1. When we took a look at where Monday's machine was, we did a little bit of a little field trip. And in case anyone didn't see it, I found a nice hill. It took on a little bit of a Murdaugh turn there because I was looking at the Monday's machine place, and then I saw this hill, and then I was like, oh, look at that nice hill. And then we went on the whole detour trying to meet the hill, and we got kind of close. Anyway, but what she's saying is the video surveillance from there exists, but they don't have it. And that video surveillance would show the car if it was there in that time frame, but it doesn't exist. Like, okay, wait, sorry, it exists, but they don't have it. Let me just back it up one more time, just to make sure I'm like, that's what I'm
Fine. That clearly was given to Moscow Police Department.
Yeah, okay, yep.
That's also south on 95.
Yeah. So Moscow PD has the video surveillance from Monday's mechanic place.
Yes, ma'am.
Okay. I understand that you had a lot of help on canvassing and collecting things. There's a lot to do. But as the lead agent and the lead department, is there some kind of inventory of these videos, like a general inventory that would help me know what you have and why you don't have the relevant timeframes?
The inventory that would be most useful to you is the inventory of evidence that has been booked into the Moscow Police Department. That's the inventory.
And I did come see the evidence. That's fair. I did come see the evidence. We didn't watch videos together, though, did we?
No, ma'am.
And would you agree that that evidence is on thumb drives with stickies on papers that tell us different things, but not like an inventory of what's on each thumb drive?
I am not aware of an inventory of each individual thumb drive.
Okay. So for us to do that together would take some days to inventory it all together. Is that right?
Yes, ma'am.
And that's my best way to try to find this Monday's machine.
Sure.
And Watson Kari Construction.
Yes, ma'am.
Okay. That's it. Thanks.
All right, Ms. Taylor, anything to follow up on that, the Jennings?
Just one second. I just want to clarify what's in your probable cause affidavit. Does your probable cause affidavit state that Kohberger or White Elantra went on US 95 south of Moscow?
No, it's not.
Okay. What does it state?
Memory serves states that the next time, well, it states that
Hold on, I need to go forward a little bit. Hold on, sorry guys.
this is a possible route of travel between the two locations.
This is the part that I need, is this redirect. Hold on.
Mr. Kohberger did not use Highway 95 south of Moscow on November 13th.
I'm testifying that there are various routes that a person could
Yeah,
take.
okay. This is the part we needed. Okay, let me just jump back just a second. That's what we
South
need.
of Moscow on November 13th.
By Watson Kari Construction?
I do not believe it does.
Did you attempt to obtain surveillance on that path of travel that doesn't go through 95?
Yes, we did.
And were you successful?
I don't believe we were.
I don't have anything further.
Okay, thank you, Ms. Taylor.
Are you testifying that Mr. Kohberger did not use Highway 95 south of Moscow on November 13th?
I'm testifying that there are various routes that a person could take south of Moscow to include Highway 95. There are also several others.
Which one does your map depict?
I believe the map starts well south of
guys,
Moscow, forward more towards Genesee, and there is the line that starts there. However, I would direct you to the paragraph at the beginning of the map that says this is a possible route of travel between the two locations.
So you're just not sure.
Yes, ma'am.
Okay. That would include then Highway 95 south of Moscow.
Yes, ma'am. What?
And that would include other possible routes.
Yes, ma'am.
How many video surveillance
This.
attempts did you make to get video
This is getting to the heart of it right here.
from businesses or homes on all of those routes?
I do not recall, but it continued for some time, attempting to find additional video footage.
What did you find?
Nothing to my recollection.
Nothing.
Not one video depicting the
That.
car.
To my memory, no.
Good enough, thanks.
All right,
So that's the point.
thank you.
Your Honor, what I'd like to do is I'd like to start with
So let me back that up just one more time here. Just hear that.
what did you find?
Nothing to my recollection.
Not one video depicting the car.
To my memory, no.
Good enough, thanks.
All right,
All right. So let me jump forward just a smidgen. Here you go. To the argument.
The grand jury subpoenas, and then I'll cover the rest of this morning's argument.
okay, thank you.
All right, so real quick before we start, so depicts the universe. I wanted to say also, I double majored in violin performance with I also double majored in music therapy for a time, and I know that DSN's wife also works in music therapy and went to school in music therapy. And I will say that is actually a big time fact, where music works wonders with like Alzheimer's and dementia patients. And in fact, I even got to work with some people when I was double majoring and did practicum, as they call it, which is when you actually go on site and work with the different people that have different things. Like, you know, we went and we worked with the young kids with all kinds of different disabilities. You may have heard the story that I've told before about how we actually went to like the, what would be called, it was a hospital for the criminally insane. That place that I've talked about, that was like out of a horror movie. And we also went to like retirement homes and stuff like that for elderly folks with dementia and Alzheimer's. And the songs is huge. Music is huge. It really is a memory trigger. So we just, you know, that's a great point. Thank you. I don't even know how I didn't think of that. You're right. Yes, indeed. Oh my God. Fucking hell. Yeah, I know, right? So, I mean, he says the possible route of travel. Here's what I will say. I will say this. Idaho Department of Transportation, if they got their act, if they had, y'all, these were state roads. If they had their video cameras, like they don't save their video. It's so bananas to say. They don't save their video footage. It gets like overwritten. If they saved it, a lot of questions could be answered, right? Potentially, if either inculpatory or exculpatory. So we just don't know unless there's an alternate route, or unless, you know, it's a different time. They got the time frame wrong or whatever. Again, some of it's going to be hard to really understand what exactly the theory is without having a little bit more information in terms of like the times. And I don't know. It's possible that it could be kind of pieced together through the affidavit, but I feel like there's so much that's left out that would be a little bit hard. Like in other words, to take the approach that we took like with Murdaugh, right? Where we went and sought to answer all the questions, right? But we had all the information that anyone's really ever going to have in that case. So we had a lot more resources, but there's just not that many resources here yet. I don't want to fill in blanks when it comes to factual information, if that makes sense. So rather than like in other words, if there were like a bunch of different times, and like the way we do with Murdaugh, right? When you have a bunch of different information, we could sort through it and we could figure it out. But you have to have the information, you know. So, but I'm welcome to whatever you guys think, because again, you know, whatever y'all's thoughts are on what the deal is with the Elantra. I don't know. We're about to hear some argument on it though, so let's see what the attorneys say. Woo! Argument time.
Your Honor, to facilitate this argument on this point, I am going to hand you defense exhibits A and B that were submitted in our records for today. I want you to be able to look at them while I'm talking.
Thank you.
As of today,
So as it's, I have the label up there. This is the defense argument. I like that font. What do you guys think of that font that's up there? I like having different fonts for different trials and different phases of trials. I like that font for this, for BK hearings. So I might keep that. Let me know what you guys think. And then again, I've been putting the names, like I had when there were witnesses, I had their, it's so funny because now you just see the empty witness stand, but I had their names, you know, listed. But see, now what I'm doing is I'm putting the name of whichever attorney is arguing. So she's for the defense, Miss Masseth.
there have been at least 50 federal grand jury subpoenas that have been issued in this case.
That's a lot.
Exhibits A and Exhibits B are an example of copies of grand jury subpoenas that we have received out of those more than 50. And what I didn't provide to you that goes behind that what we got with those is the subpoenas include attachment A, which explains what is being subpoenaed. And then what has been produced is the responses to those subpoenas. And in some of the subpoenas, we also have the certification by the person who has produced the records in response to the subpoena. Some of them are missing. We have asked the state to produce all of the subpoenas. And their response is that they are not in possession and control of those subpoenas, and they do not.
I love the way the word subpoenas is spelled.
Intend to use the subpoenas as an exhibit, and we have not justified why we need those subpoenas, and for those reasons, they are not going to produce them. I'd like to begin by saying that as it relates to any argument that the state is not in possession and control, rather than beat the dead horse on that issue, Idaho Supreme Court came down in 2023 and made it crystal clear that anybody that's acting on behalf of as an agent of the state puts those records in the hands of the state, and they need to produce them. State versus Pendleton, 2003. The other thing is that in terms of the state arguing that they are not going to use a subpoena as an exhibit, that is not in and of itself a defense to not produce a document to us. We have a million reasons why we need to look at documents. We understand that out of the 51 terabytes that have been produced, that not all of that is evidence that's going to be coming before the court or the jury, but it doesn't mean that they aren't material or exculpatory. The subpoenas, based on reviewing the records, are in the hands of basically three agents. There is an FBI forensic agent by the name of forensic accountant, Michael Douglas. There's a special agent, Travis Shirley, and there is another agent, Mary Tyndall. These are the three agents that are receiving.
Am I crazy? Wasn't Michael Douglas mentioned just recently somewhere else? Was Michael Douglas referenced with Chad? Wasn't there a Michael Douglas? I'm trying to remember. I feel like it was one of the family members when they were doing like victim impact statements. Was it Michael Douglas, or was it was like another celebrity name, right? Do you guys remember who I'm talking about? Wasn't it Michael Douglas, or was it a different? There was another celebrity name, but I thought it was Michael Douglas. I feel like I've heard Michael Douglas so much recently. Like, what is happening? Do y'all remember?
Subpoenas, reaching out to the providers that they're serving and asking for the documents. For the court to understand why we need these documents, I want to tell you what we're doing with discovery and timelines. There are more than 100 search warrants in this case. There are more than 50 grand jury subpoenas in this case. You've heard all kinds of information about the probable cause affidavit and the timing of that. Timing in this case for the defense is everything. So we are creating timelines that put in the dates of affidavits of warrants, the information that's received, and the date that it's produced. With subpoenas, when we don't get a copy of the subpoena and all we get is the warrant or is the subpoena return,
Maybe. I feel like there was a family member though. I swear. I made a joke, but see, it was to myself because I wasn't live streaming it and I was like, I was listening to it. I wasn't in a chat. So I made a joke to myself about it, but like you guys didn't hear me make the joke to myself. So, that's the thing. But I thought there was another Michael Douglas, like one of Tammy's family members. Oh my God. It was like the last one to testify, or not testify. It was like, testify, like victim impact statements. Wasn't it Michael Douglas? Do you guys remember? I think he went last. I swear it was Michael Douglas. Also, Super Planner Girl, if you're still listening, I meant to answer this question of yours earlier, and I just realized that I did not because I was doing other things, probably singing. But if you're still here, you were asking about Triple R at some point. I haven't heard from her since, what day was that? Thursday, maybe? Aha! Thank you, Copper Horse. I know things. See, guys? I know things. Yes. All right. See, it all comes full circle. How crazy is that? Because you know what? This was like, what day were the victim impact statements? Actually, I was going to say, wouldn't it be crazy if these happened on the same day? This hearing was on Thursday. I guess the victim impact statements was on Friday. So yeah. Okay, good. So yes. So I haven't heard from her since Thursday, but I will say that it's interesting because like on Telegram, it's showing that she's not been on there since Thursday morning. And then I also tried using iMessage and it's not like, how like if your iMessage is like deactivated or your how like it does like send as text instead of iCloud. It's like green instead of blue. Like usually the bubbles are all blue and they used to be blue. And like it would try to send it and then it couldn't send it. And then it put it green and it was like send as text message. And like it doesn't show you if someone's read something or not on there. But basically the fact that it's green, it would I'm wondering if it is something to do with her accounts being she deactivated it or something was hacked. Yeah. I have not tried Discord, but I would imagine that if she's not using even like basic phone stuff, she's probably not using Discord or able to, or whatever the case is. I don't really know, but it looks like there's like, she's not leaving any type of, what's the right word? Like digital footprint, I guess would be the word. Wow. Yeah. We could use an expert on this, right? And I've called as well. I've called and I've texted her and I was like, I don't know how to get in touch with you if we can't get through with like all the different, like, I don't know what to do because, she and I are super tight, as y'all know, but I don't have any, like, of all the ways I have to get in touch with her, none of them are working. So, and it like, in other words, the benefit of Telegram in certain instances, as y'all know, or well, maybe y'all don't know, I love Telegram. The benefit of Telegram in certain instances is like, it shows when somebody was last there. So like, versus like on iMessage, you can like have it choose to send read receipts or not. On Telegram, it's way more detailed. So Telegram, it shows like when the person's online and it shows if they were last seen, whether or not they even opened up your message or not, it shows when they were last seen. So like, that's actually really helpful, especially if you're like, where is somebody okay, for example, and then as far as the messages and calls that you send, it shows you if they've seen or gotten a notification for a message or a call, and then it shows if they've read it. So there's like different levels, but it makes it really, in my opinion, part of that's why it's like, clearly they haven't been there, right? Like, because it says like she was last there online since it was on Thursday. So anyway, highly recommend Telegram for anyone who has not tried it. It is a way better version. Like for me, I tell everybody like I greatly prefer it. I don't even really use iMessage anymore. All my students are on Telegram and I'm trying to get all my family and friends switched over to Telegram because I think it's better. Anyway. All right.
And in some of them, we don't know that there is a certified return. So we can't take our timeline on warrants and our timeline on the probable cause affidavit and our timeline on everything else that we're putting in there and interlay the subpoena information that the state is getting. And we are desperate to find out the timeline in this case and when the state knew what and when. There's no question that motions to suppress are coming. Motions to suppress are coming on warrants. And whether or not those motions to suppress are based on Frank's material because misrepresentations are made depends on the timeline. So if there's a representation made in a warrant.
You know what I'm hearing? I'm hearing that we have every right to be confused about the timeline because that's what she's saying, right? Like what I was just saying in reference to Needs and Z's question a few minutes ago. Needs and Z's, if you're still listening, your question. Let me see if I can find it. Bloop, 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 bloop. Well, yeah. So you had a question. It was regarding. Wait, did I just see it? Did I just scroll by? Here we go. Yeah. And I was like saying how like I just feel like we don't really have enough information to even really fully examine the timeline. You know what it reminds me of? It kind of reminds me of Karen Reed. I mean, completely different, right? But in the sense that like there's a lot of questions with Karen Reed that we're like we just don't have enough information. We should at this point. They're completely different situations in the sense that we should have information. We should know. In this case, we shouldn't know, right? It's waiting for trial. But the similarity being that without enough information, the timeline is difficult. And so anyway, the attorney feels the same way that the timeline, they can't even go over the time. And, I can see now, let me just say this much, guys. We've made a lot of fun of the alibi, myself included. Everybody has. In terms of the alibi, I can see, I will say, I'm seeing things differently after the information that came out from this hearing. I'm seeing things differently. Here's why. Because you can imagine that it would be hard for them to fully present what they need for their alibi defense as they've been trying to, because it's been a joke so far, right? But without having the information regarding the timeline. Now, I understand, right? If he wasn't there, you should be able to say he wasn't there and that's that, right? Yes. But, it is tricky if someone's alone. Like for someone that lives alone, and for someone like that works from home, for example, like there's people who actually have lives where like legitimately they could be completely not at somewhere, right? They could be at home asleep, or they could be out stargazing or whatever the fuck it is. But it could be there's some times where that could be hard to prove if there's not another person with them or whatever the case may be. If they don't have like a Fitbit or whatever, I don't know, some things that people have. So you can see how I think that's probably what this is going to come to. I don't think they really talked much about the alibi so far in this hearing. Actually, they didn't, but the timeline matters regardless, right? So
that's things happen in a certain way. If we are able to look at the timeline and say, we know that the state knew this when, that gives us an answer on whether or not the suppression issue includes a truthful statement in the affidavit. And if I'm not making sense, I want you to tell me to clarify that. But we need to know the timeline of all of the evidence in this case and when the state knew what it knew, or why certain things were being looked at before Mr. Kohberger's arrest or well into late in the year in 2023 related to the victims, and try to piece together, is that something that the state is still seeking because they're pursuing the alternate suspects that exist in this case? There's so many things that we're trying to understand. So what we're asking you to do is enter an order compelling them to produce the subpoenas.
Motion to compel. That's why we're here.
You see that they had at least two in their possession that they possess, and it will clarify it for us. And we will be able to create our timeline and put all of these things together and know when and why the state was doing these things. And just to add one other component, you know, you're hearing about cell phone records and cell phone records today being produced on warrants. Well, there were several sets of cell phone records that were produced pursuant to a grand jury subpoena. Still not clear to us why warrant versus subpoena, and they're different providers. And some of it's for phone numbers that we have to figure out.
That's interesting. I can't, you guys have to, I'm going to be candid here. If y'all knew how many times I have actually been parsing through these documents and trying to figure out why is this in a warrant and why is this in a subpoena for this case. And I thought, well, it's just because it's like, I'm like, well, I thought I really understood this shit, like with legal, like but I'm like, but I guess there's something I'm missing here, blah, blah. I thought maybe it was just like at the limits of my knowledge or what have you. But no, apparently they don't get it either. Let me back that up and let's hear that again, because that's actually pretty substantial.
Produced pursuant to a grand jury subpoena. Still not clear to us why warrant versus subpoena.
She said it's still not clear to us why warrant. I'm like, oh, wait, hang on. That because it's not been clear to me, but I thought that was just me. So
and they're different providers, and some of it's for phone numbers that we have to figure out who those phone numbers are. But all of this information is critical and material for us to be able to do the case, to do our work in this case. So I would ask that you enter an order to compel, and that way the state has the ability to take that to the FBI agents and say, the court has entered an order, we've got to produce the subpoenas, and we'll get the subpoenas. And to the extent that the state may stand up and say, we've got this 2E demands, we've got to deal with 2E. I just want to make it really clear for the court that 2E is not an obstacle. 2E is a hoop to jump through.
Does anyone here need me to explain 2E, or do y'all know what 2E is? I just don't want to be like redundant, but just I can explain that if y'all want.
The code related to 28 CFR 16.21 specifically states that the purpose of 2E is not to prevent federal agents from giving states discovery in a criminal case. Purpose of 2E is because these federal departments want to know when certain records are leaving their files. Understandable, but it's not meant to keep us from getting records that we need in this case.
Thank you. Response?
Mr. Judge.
Yes.
Well, simply put, we can't give over what we don't have. And we do not have the majority of these subpoenas. What we do have, we've turned over. I reached out to the U.S. Attorney's Office. They advised they're not going to provide.
What? Why?
Because they don't provide subpoenas. Just like most grand jury material, it's sealed and not typically provided.
Not typically.
Not provided.
But even with a 2E letter.
Interesting, y'all. Judge is skeptical. This is the prosecution. They're saying that the what did she call it? The not attorney general. Hold on. What did she say? Let me back it up.
Advised, they're not going to provide.
What? Why?
Because they don't provide subpoenas. Mr. Judge.
Yes.
Well, simply put, we can't give over what we don't have. And we do not have the majority of these subpoenas. What we do have, we've turned over. I reached out to the U.S. Attorney's Office. They advised
the U.S. Attorney's Office. So it seems like he's not buying that the U.S. Attorney's Office can't interfere here and help.
They're not going to provide.
What? Why?
Because they don't provide subpoenas. Just like most grand jury material, it's sealed and not typically provided.
Not typically.
Not provided.
But even with a 2E letter, that wouldn't give it. We provide. They wouldn't follow that.
We have not. I'm not sure. But beyond that, though, even if they were to provide it, I still don't understand how this moves the needle one way or the other.
Huh.
You can tell, I've detailed, there's 71 federal grand jury subpoenas. And in my response, I've detailed exactly what they were for and what records were received so that you can get the scope of what was requested from the actual records. The piece of paper that was given over saying, give us these records, is all they're asking for. But they have the records. They have the important part of this.
So they have the timing based on the subpoenas
Off of
that
the
you've
records.
provided to the defense.
Off of the records provided. You can tell the scope as well as what they're for. And I've detailed exactly what they were for, the scope, in my response.
Any response?
I wouldn't be wasting the court's time asking for this if the questions were answered based on the state's response to our request for discovery. Timing is critical on when a subpoena is served, what was the scope, then we can look at the documents to see if they are actually responsive to the scope. And knowing the timing of when that was served versus when it's produced to us is different. And again, I mentioned some of these things are pre-arrest of Mr. Kohberger, and some of it is in the middle, and some of it is, frankly, months after the fact, if not a year after the fact, where they're looking for things related to the victims.
So
And-
can I ask a question? Because Ms. Jennings just said that that the dates, well, all the subpoenas that were provided to you, 71 subpoenas, and each one of those had the scope of what the request was in the subpoena, and that it would be dated. No,
That's not true.
that's not.
That's not true. No.
Okay.
There are all kinds of different records and different methods that the people that were the businesses and the people that were asked to produce the records produce them in different form. I do not know when they received the subpoena, the timing of it, and I do not know for all of these what was the scope of what was asked for versus what was produced. I do know what's produced, but I don't know the timing. And the answer of the date discovery provided, which is in Exhibit 1, that the date that a discovery is provided to us doesn't answer the first two questions that I have, which is the timing of when they asked for it and the scope that was stated in the subpoena of what they asked for. Some companies were asked probably for a certain number of months, and they didn't have records that were responsive to those number of months, right? Because when the state's doing this investigation, they're not necessarily knowing exactly what records exist. So being able to be specific is important. And I want to touch on this issue of it. It's not in their possession. I get that. But you have complete control over what evidence is going to be coming into this case with your orders. You make it crystal clear. Produce it or it's not coming in. That's the first level of sanction. And then we can just get going from there. Something that's destroyed, you can't produce that. There's going to be a spoliation instruction. Something that we keep repeatedly asking for and it gets past time, we're going to knock the death penalty off the table. You have control to get these issues that we're struggling with fixed by saying, this is my order, produce it, or there's going to be a sanction.
You may be overestimating my power.
I think
can't
you're
control everything.
underestimating your power.
Well, I have a good
Wow,
sense of
Paul.
where my power starts and
I just
ends.
did-
So
Wow. Yeah, no, I would agree with that. Yeah, this is, and I mean, the judge is kind of calling them out there, like almost like on the BS of like, I don't know, man. But he's doing that. He's being fair about it. He's kind of calling BS for both sides in a sense here. Right. Yeah, absolutely. That's a great, yeah, especially the defense is concerned that the state is trying to reverse engineer. Yeah, for sure. For sure.
I don't.
Did anybody?
I don't know.
Did anyone need me to explain TUI? I'll do it just in case. So TUI is whenever it's a subpoena for another government for a government entity that's not party to the case. So you often hear TUI in conjunction with FBI. So like you may have heard it in other cases. So whenever they're talking about TUI, they're talking about subpoenas that they've sent to the FBI for information the FBI has from when the FBI assisted Moscow PD.
There's so much discovery that has been shared. Are all of these 71 subpoenas, have they been provided to me at this point? Because I don't think I've seen those.
No, they went through a federal grand jury. So this is, we haven't seen anything in terms of grand jury testimony, transcripts. What I have surmised based on my federal practice, because I spent about 50% of my time in federal court, is that they've used a federal grand jury as an investigative tool because the FBI is partnering with them. That makes complete sense. These subpoenas are in the hands of the 3 agents that I gave you the names of. They haven't come through you. They're in the hands of the agents. And so it's a matter of them just gathering the records that those agents have in their possession and providing to us, and it helps us create this timeline in a case where discovery is being given to us as if we're living in a snow globe and it's just swirling around us.
Wow.
And we're constantly having to put it together.
Wow.
So, you've asked us several times, what can I do to help you guys get your work done? This is one of those things.
Wow.
Let us see the subpoenas so we can overlay this in our timeline.
But you just want the subpoenas. You don't necessarily are going to get the response.
We have the responses. We have the records. But what the records don't tell us is what was in the subpoena. It's like a warrant return.
Right. I see what she's saying.
What is a warrant based on? It's based on an affidavit.
He wants to know what they were looking for and why they were looking for it.
David.
Yeah.
So
Right?
this is what you want, the paper that says
And the
this is
exhibit.
what we want.
And the Exhibit A that's attached to that, which I didn't give you a copy of Exhibit A, but Exhibit A is attached to each one of those. And then it specifies to the company, you're looking for phone numbers that are this, and this for these dates.
That doesn't have the date on that
and
when it was served.
those subpoenas tell us we know when they are served because it comes back with a date on it.
Mm-hmm.
And then
Right.
and then the attachment A has the scope of what they've asked for. What we've gotten is the documents without. It's like not having the affidavit to the warrant return.
Okay. I think I understand that. And I'm going to go back to Ms. Jennings and just.
I understand it. So that's a good example when she says like not having the affidavit to the warrant return. It's like the warrant return is the last thing, right? Like you have an affidavit, then you have a search warrant, then you have a search warrant return. The search warrant would be based on things that are in the affidavit. And then the search warrant return is based on the search warrant, right? It's like, here's what we went and searched for. And then the search warrant return is like, here's what we found. But you can't have the search warrant without the affidavit. So I see what she's saying. That makes sense to me.
Clarify. What have they been given?
Although I feel like there could have been probably a
They have
similar.
been given records in response to all 71 of those federal grand jury subpoenas.
Do they have dated on there? Because that's.
Many of them do. You can see that from the description of the conference that I provided to the court. I can't say that all of them do, but many of them do.
Well, that's
They're
very
running-
important, apparently, for the defense, because Ms. Mathis said that timing is everything here. So I think that's what they're really after. That's one of the things they're after.
Yeah.
Is just
Put the
the
dates on
time
the thing,
frame.
people.
We can seek to inquire as to, because what I keep hearing is they need to know the date that these various companies received the subpoena. We can still inquire. It's provided on a lot of these,
Right.
but on the ones we're missing, we can attempt to inquire and find out the date that it was served. And we can still do that without providing the piece of paper.
Well, besides the timing, what's the relevance to this scope that was requested?
What's the relevance? But
Yeah.
we're not relying on any of these.
I know. I don't think you're. What do you think they think is relevant?
Yeah, for sure.
Okay. Mr. Thompson, so what is the relevance? But aside with the timing, okay, and the scope.
Judge, I'm not going to give you the specific date right now in open court on one of the subpoenas, but they used a subpoena to get one of the most critical pieces of evidence in this case. And they know that.
Okay.
And they are going to use that.
No, response.
It's something that I don't know about.
Well, I mean, you probably you do know of it. It's in the probable cause affidavit.
Okay. Thank you. All right, Ms. Jennings.
What I can tell you is that for the majority of the stuff,
Guys.
we did state search warrants, and we've received many of these records that way.
Okay. Thank you.
Hold on, let's back
All
that
right.
up.
Enough with that. Thank you.
I'm
Majority of
curious.
the stuff, we did state search warrants. No, response.
It's something that I don't know about.
Well, I mean, you probably you do know of it. It's in the probable cause affidavit.
Okay. Thank you.
Hold on,
All
let me
right,
back
Ms. Jennings.
What I can tell you is that for the majority of the stuff,
Oh, sorry, I didn't see your question, Super Planner Girl. Random question. Do you think they expected his defense to not care as much? Potentially. Potentially, unfortunately and sadly, that happens sometimes with, and that's, again, I keep saying that's part of why this actually is great. It's a good thing because everybody should care and everyone should expect everyone else to care. You know what I mean? So I hate that. Anytime somebody breaks a stigma, I love that. First of all, doesn't even matter what it is. I love anything that's gives the middle finger to the stigma. And there's a long standing stigma, and maybe those of us who really know trials we wouldn't maybe say this, but I feel like among the general public, for example, right? There's even that term, instead of public defender, they make the joke and they say public pretender, right? I don't know if y'all have heard that, but so there's a stigma, right? That you're getting a shitty attorney if it's court appointed. And then there's also stigma that defense attorneys just suck in general, right? Anytime that anybody gives the middle finger to a stigma, I'm all for it. So, yeah, but in other words, that I wouldn't be surprised, right? I wouldn't be surprised if that were the case, Super Planner Girl, sadly. Yeah, I agree. I totally agree. And I don't even know, I agree. I think that the unpreparedness and things maybe complacency, right? And I guess also I'm thinking more in terms of maybe from the law enforcement, the dude who didn't save his work on the computer. Why not save it? It doesn't take time. You just hit the save button. It's not that hard, right? And now look at all the trouble that's coming. Just shit like that, right? It's just stuff that could have been prevented. Labeling things correctly so that they're organized and they can find the videos they need, for example, right? And then, and of course, again, I'm not going to let it go. The Department of Transportation having their videos not immediately deleted. My God, I mean, so just shit like that, right? Yeah, I agree, though. I definitely agree with that.
we did state search warrants, and we've received many of these records that way.
Okay, thank you. All right, enough with that. Thank you very much. Appreciate it.
Your Honor, again, where I want to start is with Idaho Criminal Rule 16 that governs discovery. 16A directs which things are mandatory disclosures from the state. Those are things I don't even have to ask.
Oh, I missed it.
And those are items that
I sidetracked myself. I meant to go back so I could hear the thing that she's referring to that's in the PCA. It sounds important.
You do know of it. It's in the probable on one of the subpoenas, but they used a subpoena to get one of the most critical pieces of evidence in this case. And they know that.
Okay.
And they are going to use that.
No response.
It's something that I don't know of.
I mean, you probably you do know of it. It's in the probable cause affidavit.
Okay. Thank you. All right, Ms. Jennings, you
What
want?
I can tell you is that for the majority of the stuff, we did state search warrants, and we've received many of these records that way.
Okay, thank you. All right, enough with that. Thank you very much. Appreciate it.
Your Honor, then where I want to start is with Idaho Criminal Rule 16, which governs discovery. 16A
Okay, so now
directs
you're
which things are mandatory disclosures from the state. Those are things I don't even have to ask for. And those are items that the state has possession and control over that would tend to negate guilt or reduce punishment. 16B is the portion of the rule that governs when I request items in the course of my preparation of the case. And I would have the court keep in mind 16A and the prosecutor's responsibilities and Idaho Criminal Rule 16B and the discovery requests that we've made and what we have not received. We've asked for documents, we've asked for reports, we've asked for qualifications and summaries from experts, and we've asked for media that's been gathered in the case. The court can order other things that we asked for based on the need of the case. I would remind the court of the case that Ms. Massa just talked to the court about, State versus Pendleton. I know the court's familiar with this. This is a good case because it's recent and because it takes the time to define what's material and what's within the possession and control of the state. We need to think about our motion to compel in the order we are requesting from you in the context of what's in the possession and control of the state. Your Honor, the State versus Pendleton case says that any law enforcement, and this includes the prosecutor's office, it includes their staff, it includes any law enforcement that worked with them on the case. In this case, you're looking at Moscow Police Department, Idaho State Police Department, Idaho State Police Forensics Lab, and FBI agents, to name a few. So what those entities have and have developed are within the possession and control of the prosecutor. So with that backdrop, I want to run through our specific requests and talk about what we need. You've heard testimony, and so I think you know why these things are material, but let's go over it again. Starting with the fourth motion to compel, Ms. Massoff went over 1A, the grand jury subpoenas. I'm going to leave that argument alone. She did a fabulous job with that. When we're looking at 2A, this all comes from the defendant's 11th supplemental request for discovery. 2A is the video on King Street. Your Honor, we began asking for that a long time ago. We have it in full, so we don't have to talk about that. We received that full for all of the hours and days in question with both audio and video on 510. So we can mark 2A, item 219 off of our list.
219.
219.
And I've gone through pages and pages and pages, so I think I really appreciate you being very specific about, what you have now and what you will still.
Okay. Good, because it's the only way I can keep track of it.
Yeah, well, same here. Thank you.
You're welcome. Your Honor, item 2B in our fourth motion to compel is item 224. That's the cast biz log. And this one is rough. The court heard last week Detective Mowry say, I don't have any of those, except I found these other items that we'll give you now, which were not Mowry's cast biz logs. The hard part for us about this one, Judge, and I have to make a record. I think you can order them to double check, and I'm going to ask you to order them to double check. But the hard part of this for me is that on January 9th, we asked for these cast biz logs. And the response was from the state was cast biz does not produce logs. And
right.
That's just not true. It does. It's capable.
Yeah.
It produces logs. You've heard that in the testimony. Then we filed our motion to compel and explained we have an expert. We know it produces logs. We're going to bring them. And the response was the working files were not saved. We received that response on April 23rd, 2024. And then
that's what I kept referring to. I actually just mentioned that just a minute ago about how it wasn't saved on the cast report. Also, I'm trying to scroll through the probable cause affidavit and see if I can figure out what she was referring to. However, that might have been one of the exhibits there were multiple exhibits that were attached to the PCA that were not made public. And that could be what she was referring to that's in the PCA. As far as the what they used for the search warrant. So, but I'm scrolling through that just to see.
On May 10th, we got a little bit more explanation about default settings were used and optional session files were not uploaded. This is really, really difficult because of the varying answers that we've received. The court's heard testimony from Mr. Ray about how important these logs are to know what was done. This is really challenging. We can't recreate what Detective Mallory, who testified before the grand jury, did, unless the court orders that we get the tower list he used and we have the cast viz program. And quite frankly, that's what we want. We need to see how this work was done. This is important work. I'll tell you the other thing that's really troubling and frustrating, aside from the other files that we received in preparation for motion to compel, is these screenshots that we got for the first time last week when we're on a motion to compel and have a witness before the court. We didn't have those screenshots that Detective Mallory had created before. The only thing we had was Exhibit 48 that was given to the grand jury, which is a video that was handed over then. So this is really problematic to be told these varying things and then have something else produced on the day of testimony. Your Honor, we are going to request that the court order that we have the tower list used by Detective Mallory and access to the cast viz program. So our expert, Mr. Cy Ray, can go through and see what Detective Mallory did. That it's imperative that we be allowed to do that. That's the only way to recreate what Detective Mallory did.
It seems to me he did acknowledge that he just went back and provided this a day or 2 days before he testified that he found this additional information. So I'm thinking that the state got that information and had provided that to you. Now, we also heard a lot of the quotes missing pieces today, which I'm guessing that FBI, Mr. Valance, and Detective Mallory are going to go back through that and see if there's.
I just wanted to say something. Reading through this PCA, I think we should. I know I keep saying this to myself. I think we should go over this. I think this would be good. But I wanted to read just this one specific part regarding the phones, because we've talked about this before here in this case with, was his phone off? Was it in airplane mode? Whatever that case may be, because I remember, as we've discussed, we've heard a lot of people, whenever people are talking about this case in, podcasts and on the news and whatever, everybody says this phone was on airplane mode. I say everybody, not the attorneys, but everybody else. They all say, oh, his phone was on airplane mode. I think because that's become kind of like a buzzword. We have never heard the attorneys confirm that it was on airplane mode. We've never heard anyone confirm that. And you know what? It's like, it was always a red flag to me when I heard people say that, because I'm like, I know from Murdaugh and other cases as well, but we studied the fuck out of the cell phone stuff. And I know for a fact it's so hard to know for sure with the cell phones. And that's a fact that has to be decided on by the jury from information presented at trial. Like, I think that it's tough to actually really know for sure. And the different experts will say different things versus what's the deal, right? Like, are they out of service? Are they not getting, is the phone off? The SIM card, we hear about that a lot, there's a lot of different things. And so, but everybody talks about it like it was for sure on airplane mode. Oh, good night, Super Planner Girl. Talk to you tomorrow. And just in case you didn't see, I'm also covering the trial tomorrow for Karen Reed live tomorrow morning. But I want to go back to the languaging that's in the affidavit, the PCA, because what's in here, as far as his phone is concerned, is this is as much information as what we know about his phone. We don't there and nothing. We're not going to learn anything else likely until trial, unless we can kind of glean or infer little things from the hearings. But I feel like the actual like what the status was, that's going to happen at trial. So here's what it says though here. I want to get the language incorrect. At approximately 2:47 a.m., the 8458 phone, that's the phone connected to Kohberger, stops reporting to the network, which is consistent with either the phone being in an area without cellular coverage. Like this is exactly what I just said. That's so funny. The connection to the network is disabled, such as putting the phone in airplane mode, or that the phone is turned off. Those are, and actually that's the three things I just gave an examples of. Yeah. So you could be out of, without coverage, turn it off, or put it on airplane mode. It's three different options. So anytime you guys, anyone that's listening, anytime y'all hear somebody say, oh, his phone was on airplane mode, you can tell them, we don't know. We don't know. It could be any of those three things: airplane mode, turned off, or he's out of coverage, out of network, out of range, whatever you want to say. And then it says the 8458 phone does not report to the network again until approximately 4:48 a.m., at which time it utilized cellular resources that provide coverage to ID State Highway 95. Now this is interesting because this is exactly where we just heard Ann Taylor ask Brett Payne. He said this is where they don't see his car at this juncture, right? With the I guess it's on the way home. Yeah, so that's exactly this. It says ID Highway Highway 95 south of Moscow, between 4:50 and 5:26. The phone utilizes cellular resources that are consistent with 8458 phone traveling south on Idaho State Highway. So what the problem is that they have his phone, I guess, now responding to the network in that area between 4:50 and 5:26. So after the murders, they have his phone placed. They're placing his phone on Highway 95, Idaho State Highway 95. However, like we just heard at the end of the testimony clip, they did not spot. I think they said any white. He said any White Elantra. So that's interesting. That could be enough there that they could work with to try to work on an alibi defense. By they, I mean the defense. I'm just reading a little bit more here. And then, of course, it says at 5:30, the phone is utilizing resources that provide coverage to Pullman. So that all makes sense. And then that's interesting. Then it says, based on a review of 8458 phone's estimated locations and travel, the 8458 phone travel is consistent with that of the White Elantra. But it's failing to mention that it's not consistent, though, because it doesn't match up with his drive home with what you have on the highway. Like the phone is placed on the highway, like I said, but the vehicle's not. See, this is the way my brain works. My brain wants to hear them back to back. I'm gonna go back and then we'll come back to where we were because I think this is really important. So let me see where we were here. Okay, let me jump back and then we will come right back. I just want to hear the end of this part, the part that's relevant here. And then compare it exactly to the languaging in this PCA because I think this is important. Forward a little bit. It's on redirect. Wait, not argument though. We need a. Hold on. Okay.
Mr. Kohberger did not use Highway 95 south of
Let
Moscow
me go back a little
on
bit.
November
That's
3rd.
exactly it, though. A little bit context. Here we go.
Mr. Kohberger did not use Highway 95 south of Moscow on November 13th.
I'm testifying that there are various routes that a person could take south of Moscow to include Highway 95. There are also several others.
Which one does your map depict?
I believe the map starts well south of Moscow, more towards Genesee, and there is the line that starts there. However, I would direct you to the paragraph at the beginning of the map that says this is a possible route of travel between the two locations.
So you're just not sure.
Yes, ma'am.
Okay. That would include then Highway 95 south of Moscow.
Yes, ma'am.
And that would include other possible routes.
Yes, ma'am.
How many video surveillance attempts did you make to get video from businesses or homes on all of those routes?
I do not recall, but it continued for some time, attempting to find additional video footage.
What did you find?
Nothing to my recollection.
Not one video depicting the
This.
car.
To my memory, no.
They didn't find any videos depicting the car. Okay, let's summarize this. This is important. They didn't find one video depicting the car on Idaho State Highway, or one picture or video, whatever. Video or picture, depicting car on Idaho State Highway 95 at that time between when he would be on the drive home. So like 4:50 to 5:26 time period, right? They didn't see the car. However, I feel like I just need to show you all this. It's because I want, okay, so here's the thing. I was sharing my screen earlier. Y'all are like, what is going on? I was sharing my screen earlier, and then I went ahead and turned off my second monitor and stuff just to like not use up the, technology and stuff, how that works. I don't know how it works clearly, but I'm going to just get it back on so I can show you guys, because I want you guys to be able to read things for yourself, see things for yourself, and understand, and not just be like that I'm telling you, because that's not how it works. It's not me telling you. Like, I mean, I'm reading it, but anyway, you guys know what I mean. So let me share my screen. Not cancel, share. Goodness. Come on. Bloop, 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 bloop. Okay. All right, guys. So we're back with the affidavit. This is what I wanted to show y'all. So I was just a minute ago reading. This is where I was reading. So, let's just go ahead and do this the right way. Let's go back to where we were talking about the phone being on airplane mode, quote unquote, as everybody says, right? I want you guys to see this. At approximately 2:47 a.m., the 8458 phone stops reporting to the network. This is the key part, which is consistent with either the phone being in an area without cellular coverage. Oh no. The connection to the network is disabled. Oh my God, what is happening? Such as putting the phone in airplane mode. We're just going to roll with it. We've got a square happening. We got another square, all the squares. Or that the phone is turned off. So 3 options. Okay, that's what I was reading just a second ago. And then again, the 8458 phone does not report to the network until 4:48. And then at which time it utilized cellular. So the big thing is like the phone's not reporting, right? So whether it's on airplane mode, turned off, or not getting service, the phone, and that's during the time of the murders, right? And then the phone comes back to life. This is just kind of like what we see with Albert and others. Phone comes back to life at 4:48. The significance is where is it when it comes back to life, so to speak, right? It comes back to life here. The cellular resources are saying it's providing coverage to Idaho State Highway 95. Now, this is where the cell tower people come in, right? Because we know, okay? This could explain some of the confusion here. And I'll try to explain. So they're not relying here on call records, right? Or anything like that. They're not relying on iCloud data. They're relying on the cellular tower network. And that's the thing with, we know how that works, right? So especially when you don't in rural, and then again, there's a similarity here with Murdaugh in the sense that what we learned that was important from Murdaugh is going to be relevant here, because both of these are places that are very rural where there's not a lot of towers. And it's very different than in a place with a lot of towers. So it actually makes it trickier when you've got fewer towers. So, because they're going to cover a much bigger area, right? And like we saw with Murdaugh, sometimes every now and again, the phone's going to try to communicate with whichever thing it hits first. So sometimes it wasn't always the closest side of the tower, remember? So what's interesting is like it says the cellular resources that provide coverage to Idaho State Highway 95. I don't know if this helps the defense. This probably would actually help the prosecution, what I'm thinking. But what I'm thinking is that, like, but this is an affidavit, so that's what matters. Okay, but anyway, like so it could show that he's here with the phone, right? But he might not actually be there. It just depends on if that was the thing that the phone pinged from, right? If that was like the closest available network portion of the tower. So, like, for example, there were times when we remember with like Maggie, Paul, or Alex for that matter, they were close to the house and they have towers over there, right? I don't know if you guys, I can picture in my mind, there were lots of really good maps that you could actually see in the timeline from Rudovsky, and it had all the pings, right? And like there were times where they were like on Moselle Road, but they were making phone calls, and instead of hitting off the tower that was close to the house, it was pinging off the tower that was actually over there by Almeda, because there was a tower over there in Barnville, which is much farther away. But that was where it responded to, right? So if they're looking at it, that, you see what I mean? So like I'm wondering if that's kind of what's going on here. So maybe that's not where the route he took. And that could explain. So, but nonetheless, right, what we have here is they say the phone comes back to life. The cellular resources are showing coverage to Idaho State Highway 95, coverage to, right? It's not saying, it's important. The language is important. Coverage to. And again, he says here, between 4:15 and 5:26, the phone utilizes cellular resources that are consistent with the phone traveling south on Idaho State Highway 95, then traveling west towards Uniontown, and then north back into Pullman. The problem is, now we're going to go back to here one more time. What happens here? Hold on.
Thank you.
How many video surveillance attempts did you make to get video from businesses or homes on all of those routes?
I do not recall, but it continued for some time, attempting to find additional video footage.
What did you find?
Nothing to my recollection.
Not one video depicting the car.
To my memory, no.
Good enough. Thanks.
All right. Thank you.
Your Honor, what I'd like to do is I'd like to start with Ms. NASA. She's going to cover one of the requests specific to the grand jury subpoenas, and then I'll cover the rest of the grand jury. The car.
To my memory, no.
Good enough. Thanks.
Sorry, one more time.
From businesses or homes on all of those routes.
I do not recall, but it continued for some time, attempting to find additional video footage.
What did you find?
Nothing to my recollection.
Not one video depicting the car.
To my memory, no.
Good enough. Thanks.
So,
All right. Thank you.
hopefully that makes sense, tying it together with the PCA. And I'm looking at the PCA again. I'm trying to see what route. Oh my God. The thing is, this fucking hell, these maps. What a fucking mess. So are they saying, okay, I'm wondering, I'm trying to remember what route, however you say it, because I know you can say it either way. He drove, let me go back to the first maps that are useless. The route he used to get there. Okay, I'm just scrolling back in the affidavit here again. From looking at the Elantra, because of the fact that some of the cell stuff. Okay, so it looks like to get there, so suspect vehicle 1, it looks like he used State Road 270 to get to Moscow. State Road 270. So it is interesting because the cell phone then is like we just heard, it's using that Idaho, what is it, Highway 95? Yeah, Idaho State Highway 95. So two different, in other words, it's like two different routes. So one way to get there and one way to get back. If we're going off of, on the way there, they've got suspect vehicle 1. And they said it's consistent, although I didn't break all that down, but they said it was consistent with the cell phone. And then on the way back, the cell phone's saying Idaho State Highway 95, and they don't have the vehicle captured on any videos at all. That's what they're saying. They don't have any video, apart from like a like speeding off, they said, from the house or whatever, speeding off. But in terms of like getting back to Washington, they don't have it on any video at all, which is really interesting. So that's man, I'm telling you, thinking about all that, it makes it way more understandable to me. Sorry, I dropped my phone. It makes it way more understandable, all this business with like the alibi and like wanting more time and like, you know, asking, because it's like, wow, like, you know, that's big. That's big stuff to me. I don't know. What do you guys think? And Copper Horse is asking, hold on, let me pull that up. I wonder how Kohberger feels about his two powerful female attorneys. I wonder if he's infatuated with Anne. That's a question that will be probably better in context with whenever I do my PowerPoint presentation. Because that's really kind of getting more into the mind of somebody. And not that, you know, that's just, in order for me to answer that question, that would be like a whole other, like, you know, thing. I don't think that I can answer that really quite simply. I also don't think that I can give you like an answer per se. I think it's really more like, what are the possibilities and what would be in line with what we hear from like forensic pathologists. So that's more like a whole discussion that we will have when we do the, whenever I do the PowerPoint. And y'all have probably, you know, heard me talk about this for, I mean, most of you guys for a long time, right? In fact, I was working on that before I started switching over and doing the whole Murdaugh deep dive. So, but that PowerPoint will seek to get into all that. So I will save, now that I've learned how to do it, I will save that copper for when we talk about that. And that will be really relevant to that discussion in regards to the PowerPoint, where we talk more about like the psychology and stuff. So hopefully that makes sense.
Your Honor, what I'd like to do is I'd like
to jump forward to where we were. Hold on. No problem, because I saved the spot. Right here. Here's exactly where we were.
A lot going on. We have some time before trial. I just hope that everybody goes through their computers or their files or whatever they're going through so that it's complete. So what I've been watching over the last 2 months is that there have been supplemental responses to the defense. So things were coming in. They were waiting for information to come in so that they could provide that to you. So that's why I don't want to go backwards either. I just want to make sure that we are addressing what you don't have and what actually you're entitled to. So that's the tower list. I mean, I don't know anything about tower list, so I'm learning about that. I don't know that Detective Mowry addressed that, really, maybe, unless I missed that.
Your Honor, I believe he testified last week that he used the tower list that was contained in the AT&T record that he received. You heard today that that doesn't exist. And you heard today that the tower list was something different that he used. And that tower list had once that was entered, there was a selection on the program to do tower density.
I'm glad she pointed that out, because I would not, there's no way I would have figured that out unless we went back and listened to. So we listened to his testimony right after he testified. That was a week ago, right? But I did not catch that in terms of like, oh, he testified that he relied on the AT&T tower list. I remember them talking about that. I remember her asking questions, but in terms of connecting it to the fact that then we heard today that that tower list doesn't exist today, as in May 30th, when the hearing happened. That's crazy. Wow.
Like I said, it's confusing.
It is. It definitely is.
We'll keep going.
Okay, thank you.
You want the tower list?
Yes, I think I'm getting there, but I definitely want that. I want the one that Mallory used to do his cast viz work back in May of last year. That's the one I really want right now, at least at this juncture in the documents right now.
Yeah, I'm wondering if that's the list though that he didn't save, right? The cast viz. I mean, that might be part of why it doesn't exist. So no, that can't be, because Detective Mallory is the one that relied on it and also the one who didn't save his work. There's a lot of problems with that, right? With that dude. And just
I do want to clear up though, when we talk about what Detective Mallory found last week when he was preparing to testify, those are emails between him and Nick Valance. Those are JSON files from Nick Valance to Detective Mallory. None of those things that he found, other than screenshots like the exhibit that you have of his map with the different size towers depicted, other than those screenshots, the other things he had came from Nick Valance. Those were not his logs that he found. Those were not his towers that he found, just to be sure that those are still missing to the extent they exist. And we can't recreate what he did without the list and the program. Moving on.
Thank you.
Moving on then, Your Honor, is item 226. That's called.
so now here's what's going to be interesting. So now, you remember how I was saying last time, if y'all were here, for the part one with the testimony, about how we were going over like the fourth and fifth motions to compel, and I was saying how it's tough because we don't really know. Like we know, okay, again, they're compelling discovery, right? They're compelling the court to they want the court. The motion is that they're moving the court to compel the prosecution to turn over discovery, right? And so each motion pertains to any number of different items of discovery, and we don't know. It could be one thing, it could be 10 things. We don't know. And so part of my questions from last time was like, what is it they're looking for, and what's in which motion, right? The only thing we knew prior to the hearing was that the IGG is covered in the fifth motion, because they've talked about that a lot. But it's not the only thing in the fifth motion. So we know that the IGG is covered in the fifth motion, but we don't know what else is there or in the fourth motion. So, but what's interesting is here we're finally going to learn as they go through so what's happening now is they're going to go through the whole list, the laundry list, if you will, of all the things that they have wanted and asked for. And they're going to go through it. And then they're going to be like, what do we have? What don't we have? And they're all checking it. You can see Judge has a notepad. I'm sure the prosecution is. They're all going through, okay, did we turn this over? And they're going through the whole list of all the discovery. And so in doing so, you're going to get to actually hear them mention what the things are. Because they're going to give a number, and then they're going to say what it is, and then they're going to talk about whether they have it or not. And depending on if it's a simple, they already have it, then they'll move on to the next one. Or if they don't, they'll talk more. But this is how we're going to learn actually what the content is in terms of the discovery that they are moving the court to compel the prosecution to turn it over. That was a long sentence.
The Hemisphere program, also known as a timing advance report. Your Honor, this is one of the troubling areas again. The first response was that the records do not exist. There were letters exchanged between the state and us asking for more information. In one of the letters from the prosecutor, we were told that this program was not used in Bryan Kohberger's case. And then we filed a motion to compel. And we were told that the state was not in possession of the timing records. And then the next supplemental response in May of this year, just a couple of weeks ago, was to tell us that there's some new certified records from AT&T that we're going to get. I don't know what those are. I can tell you that these timing advanced reports were asked for from AT&T, from Verizon, from T-Mobile, and another cell phone company. In both of the early AT&T warrants, we called them the 48-hour, and then the extended warrants back on December 23rd, 2022.
And remember, guys, we pointed this out last time, and I timestamped it because I thought this was crazy. That initially they had that 48-hour warrant, as in a 48-hour time period for the warrant for Kohberger's cell phone records. And remember, we heard from Cy Ray about the nature of them coming back the same day with expanding that. And he was saying how that was like unheard of. Anyone who didn't see the test, see part 1, I highly recommend watching it. Again, I've got timestamps there. Both witnesses that testified, it's really important because you learn a lot. And there's a big, it's 2 very different witnesses. You have Brett Payne from the Affidavit, who wrote the Affidavit, and then you have Cy Ray, who is one of the best experts I've ever seen when it comes to cell phones. This dude is as legit as they come, and you're going to learn a lot from listening to him. But he is for the defense, but this is his first time ever working for the defense. He only has ever done prosecution as an expert witness. But he's a cell tower forensics expert. But anyway, he testified that it was really kind of unheard of for them to come back within a matter of hours on the same day with an expanded search warrant, because he says that what the information that they base that on is has to do with the cast report. He said it would have taken much longer for that to even happen. But anyway, here's what I was going to say. I timestamped this part regarding the roommate cell phones. Definitely check that out, because what they used in order to expand that search warrant, according to Brett Payne, was they based it on what was the language he used? He said the cell phone records of the surviving roommates and the victims. And I timestamped that, and I talked a lot about it in the last one, because I was like, wait, what? The way that they were able to expand what is a search warrant, right, for Kohberger, it was based on things that they found in the roommates' cell phone records, both the surviving and the victim roommates. So that can only be things that must specifically connect to him. And so that's crazy as well. I just wanted to point that out, since she was talking about that second search warrant, the expanded search warrant, just so you have a context there. When you hear the expanded search warrant, just know that one of the things that was based on, for them to obtain that, was based on the cell phone records of the roommates. And also know that according to Cy Ray, that happened in a really short period of time. That didn't seem really all that plausible for them to test the cast data, doing the drive testing, which would verify stuff with his cell phone whereabouts and with the towers. But again, for more on that, you can listen to the part 1. So
We don't have those. So I just want to make a record that I need to know what happens. Moving on then to 228, item 228. That was trying to understand what was relied upon for the second AT&T warrant. And we heard quite a bit today from Detective Payne about what he relied on for that second warrant. And that had to do with what was produced and analyzed in the first warrant. However, we asked for some emails and some communications. We know about some text messaging that we've received, but we don't have written correspondence, emailed correspondence, exchanging information, just the text messaging. So we want all of the email communication between Payne and Balance. Well, between anybody from Moscow PD and anybody from the FBI, really.
yeah, one thing I will say too, I don't really know how they're spelling this person's name. Valance, I have no idea. Sometimes it sounds like a V, sometimes it sounds like a B. It's not, his name is coming up a lot. I would imagine we're going to be hearing from him probably at some point at a future hearing, just because it seems like he was directly involved in a lot of this. So.
Your Honor, item 229 is the MAID data. I would say we received a disclosure, and I think we got that on either 510 or 517. And I'm going to need some time to have an expert help me out with that. I don't know if that's complete. I also know that in the fifth motion to compel, there is information we've asked for from Babel. That was a program that was used to help decipher some of the MAID data. And we're going to talk about that in a minute, but that one's yet to come. So I'm going to ask the court for an order compelling the state to give me all the MAID data. They may have already complied, though. And their intents to comply, I can tell you that.
What
Because
does that stand for again?
mobile advertiser. Let's see, I've got it in here.
Okay, I'm glad.
Identification number, mobile advertiser identification number.
Okay, thank you.
You're welcome. All right, Judge, we are now talking about item 242, the CAST report. The history of this is we came to the court asking for the CAST report, knowing it was relied upon last year, and the court ordered that we receive it. We received one that was stamped draft all over it. You've heard testimony about that today from Mr. Ray, and it's not a final report, and we knew that when we got it. We asked for that. We asked for the analysis behind that, and we haven't received that. We were told on February 23rd of this year that the state will provide this by March 31st. Well, March 31st came and went, and we did not get it. So on April 23rd, the state said we still don't have it.
Good night, Candace.
And then on May the 10th, the state responded to this request and said,
Thank you for being
that
here.
because we provided additional information, Mr. Kohberger's alibi, they need more time to do work on this CAST report, and they'll get it to us later. Your Honor, I think you ought to order that we get the CAST report, and I think you ought to order that we get everything that went into developing this, and we get the analysis that they made from that. This is particularly troubling. Their response, you told us something, so now we have to go reconfigure the CAST report. Let me tell you why that's troubling. Item 243 is our request. Give us a list of everything Nick Valance relied on when drafting his CAST report. And we were told Nick Valance relied on the call detail records from AT&T. Nick Valance relied upon tower records, and he relied upon the drive test data. Nowhere in there does it say, if you tell us anything about the case, we need that to rely on that too. These are records that exist. These are tower lists that exist. They go into a program. You do drive testing to understand how the device interacts with towers, and you create a report. So we're asking the court to order that we get the CAST draft report, we get the full list of everything he relied upon, and we get the analysis of what does this mean.
So another clarifying question, maybe. So I listened to the testimony today, and that it sounded like a CAST report was provided, but maybe it wasn't complete. Is what Mr. Ray suggested. But I think that maybe I'm guessing or assuming that the state provided what they had, but it maybe they're still working on it. I don't know. But didn't you get initially what they had as they characterized as the CAST report? When you say, I mean, we have problems with language, I think, especially when we're in this area, technology. And so we might be just going back and forth like this without really understanding.
That's a good point.
What we're asking for or what we're.
I think that's a really good point. That's a really, really, really good point by him, because he's right. Everyone's out of their fucking depths talking about this shit. And the languaging is really important as to, because they're what you're asking for. This is a really good point by him, that it might be adding to the confusion because of what people are calling things. I mean, I've done the same thing myself this entire time, where I'm referring to things and I'm sure I'm using different terminology. That's, so but we're all out of our depths with that, right? So I think that's a really good point by him. And also, Copper, I've had a second to think about a shorter way to answer your question, just also while I have it paused. And I thought of it the shorter way. And so the short way I will answer your question for now, again, we will talk more about psychology once we get to the PowerPoint, but the short way I can answer that question is that I think that if anything, in terms of how he feels about his female attorneys, I think that if anything, he would be intimidated by them. Just based on, okay, let me just answer, let me be specific. When I say that, this has nothing to do with him or even any guilt or innocence. Let me be specific. The psychological, like the forensic psychological profile of the person who would commit this crime, the offender, right, would be a person who would likely be intimidated by strong, powerful females, as told by, people like Dr. Mercado and Dr. Burgess and other people who are really the best in that field, and know how that works. And so, according to them, and again, this is going to be a big component in the PowerPoint, but according to them, from what I can glean, it's there would have been a factor of like being intimidated and kind of hating, maybe in a way, right? Females. So I don't know if that's like, I guess maybe a short way to answer that question, because you used the word infatuated, but I don't know that that's the right word, because in my mind that would be like that doesn't cover the factor of like the fear or the intimidation, if that makes any type of sense. Miss Smith says this part is why? Come on, comment. Okay, this part is way too scandalous. In my opinion, it seems like the state doesn't want to finalize the report until after the alibi, so they can modify the report going on alibi. Defense needs to submit alibi ex parte. Yeah, I mean, well, the problem is that I think that they're waiting on some of the stuff that they're discussing tonight, or discussed on the 30th, to submit the alibi. I think that's part of this whole thing, because remember when the last time they were talking about the alibi, they said they had a witness, an expert witness, right? And they were looking at the cell tower shit. And that was the whole thing when they were saying the hiking in the park or whatever. I forget the name of the park, but running, stargazing, all that, and again, all that sounds kind of not plausible, right? I mean, I'm a runner. I saw all kinds of problems in the way it was described. However, those were not his words. That was the way his attorneys described it. And if they're not runners, they easily could have, flubbed that. But the description that we had of the running and the stargazing didn't seem all that plausible. However, it's totally valid that they don't have the information needed to fully submit that. But I also understand the problem with the catch-22, which is that the whole point of the alibi defense, and I don't even know that every state even had, it differs state by state, right, on how that's going to work. But we've heard Judge talk about this, and I understand what he says when he talks about the catch-22, in that the point is not that they get, they absolutely need all the discovery, that all this shit needs to be turned over, right? But I totally understand also when he says that the alibi, the point of the alibi is not to hear all the information from the state and then say that you weren't there, right? Because it's an alibi. It's like saying it's being able to go ahead and establish your whereabouts before having all that. So it's tough. And I wonder, and I haven't listened to all of this ahead of time, so I will wonder if they will discuss the alibi. But we'll see. Let's find out together, huh? And we'll see. I imagine it'll come up.
Lighting.
Let me see if I can clear that up. The testimony today, when we had Detective Payne on the stand, when we talked about what did you rely on to get the second AT&T warrant, he said that there was something that Nick Valance produced and that the prosecutor had it, and he thought it was a cast draft. And then you heard from Mr. Ray, who said, I've seen the cast draft report, and maybe it's something different that Detective Payne looked at. It wasn't this big, long cast draft. The cast draft report, and I'm calling it draft because it's stamped draft. I knew it wasn't final when I received it. We got that because you ordered that the state give that to us last summer, last July. So I had this draft. I knew it wasn't final. Ms. Jennings knew it wasn't final. We've talked about it. We believed that we were going to get the final report by March 31st. We don't have that yet. It's the final report that we need. You also heard from Mr. Ray talking about the things that are mistakes in the cast draft report. These reports go through a peer review process, and they can look a little different when they come back out on the other side. Usually not vastly different, but they can. They go through their process. It's that final product that I need that. I need to know everything they relied on to do their work. I need to know what this draft report is going to look like. The court should know that when we get to trial, likely Agent Balance is going to come in and talk about his cast draft report. He's going to be an expert in the field and talk about what he found and why he found and what he relied on to do that. I'm going to come in with an expert that's going to explain what his work did. Now, if the work aligns and Nicholas Balance and our expert aligns, well, that's just going to be shorter. But right now, it's definitely not looking like that. It looks like they're going to have their side, and we're going to be talking about what the data shows.
So that was a great sneak peek into what we can expect at trial. I'm going to make a timestamp of that. That's why I love this shit, right? If you don't watch the whole hearing and you just go off I don't know. I love, I'm not going to lie. I love law and crime, court TV and stuff for certain things. I do. Fucking Vinnie Politan's my favorite person on the planet. One of them anyway. Love it. They're great resources. And but what I found is that I've stopped actually clicking on the videos that are like 5 key takeaways from blah, blah. I don't watch those anymore. I don't know how you guys feel. I'm really curious though. I don't watch those anymore. And I'll tell you why. And I've talked about it a little bit before, but it's not that they're not doing anything wrong. They're not doing anything wrong. It's just that you cannot get all the info in that period of time. It's just like with a trial. Or even one day of trial. When it's like, oh, what happened today? Say it in 30 seconds, right? Or like a talking head on, TV or whatever, where it's like, describe blah, blah, and they give them such a short period. It's just, it's not the full context. It's not enough time to even get, so, it's like, I've just stopped watching this for that reason, because I'm like, in my mind, I'm like, okay, well, it's misleading in a way to me. Not that they're misleading me. I feel disappointed when it's like, okay, here's the 5 key takeaways, right? If I used to watch that, and then I would watch it, and then come to find out there was something else really, really important in the document or the hearing, whatever the case may be, whatever the thing is. But I didn't know about it until way after. Because instead of going to the source myself, I relied on, and this is the problem, right? I relied on what Court TV or Law and Crime or whatever said the key takeaways were. Like, it almost is, it's like this. This is how I would interpret it. And I'm curious what you guys think. I would almost interpret it as like, it's meant to be a time saver. Like when Court TV or Law and Crime or whoever makes those, it's meant to be like, don't worry about reading the document. Don't worry about watching the whole hearing. Who has 3 hours anyway, right? Actually, the hearing is like 3.5 hours, but with my video cutting out the silence, it's shorter than that. So, but it's like, who has that time? Just here's the takeaways. So that way you don't have to take the time. Everyone's so busy these days. Like this is how I feel about it. Like everyone's so busy these days. We're going to make it simple. Here's the takeaways. Don't worry about watching it. Don't worry about reading the document. Right. That makes sense on the surface, right? Like that's not a bad idea. That's good intentions in a way. And again, I'm not saying that they're doing anything wrong, because they're not. It's just that it's not possible to get all the takeaways, right? And oftentimes what I've found is the people who are commenting on that stuff also didn't read a full document or watch a full hearing, because I've heard people make mistakes on that stuff. And it's understandable. There's a lot going on. There's a lot of trials. I get it. You know what I mean? But that's why I have decided that what I feel like I can rely on is going to the source. And then afterwards, I'm fine. It's fine, right? Hearing people comment on it or whatever but at least for me, in my own edification, it gets to be too confusing, right? Because also then it's like, then when you find out something later and it's like, oh, this came out in this thing. And it's like, wait, what? How did that, it just gets confusing it's like after the fact, you're like, well, wait, what? I don't remember that. Well, and then it's like, oh, well, I only watched the summary. No wonder. Right. So anyway, so what was my point though? Right. What she's saying right now is really important. Right. Okay. What she's saying right now is really important, and it's giving us an inside look as to what we can expect for trial. And this is just like one sentence, right? And I guarantee you that if anyone was to, make a summary or watch a summary or read a summary about this hearing, I would bet money on it that this wasn't mentioned. But yeah, this is actually a really good inside look at what we can expect it to look like at trial. And so by which I mean, it is fun. I get it. Like mocking is fun, right? Like I do too. Like mocking some of the silliness, right? With the alibi and stargazing. It's like but I feel like, we could say to be funny, like, oh, what is it going to look like at trial? The defense would be like, oh, you start, like, they actually have legitimate things. And that's an example of one. So whenever, everybody out of curiosity is like, what's it going to look like? What this and that, that is a really great example that you wouldn't have if you didn't watch the entire hearing. So that's what I wanted to say, because I wanted to point out the example, but then of course, now I got talking about why I think it's important to go right to the source. But that would be a great example, right? So yeah.
So what I want is the final report that we were told would be available by March 31st. I need time to work on it.
Sure.
What I want is a full list of what was used to create that report, what was relied on. I have to be able to see if I can recreate that.
Right.
I have to see what was right with it and what was wrong with it. So I don't have those two things, right?
Is it possible that it's just not completed?
It is possible.
A final report?
It is possible, but I need you to order that come to me.
Right.
And I don't think Ms. Jennings doesn't want to give it to me. But if you order that I get it, then I'm going to get it a lot sooner, I think. I'm not saying that Ms. Jennings is sitting holding it behind her back. I'm saying I don't now know what's going on. The FBI told her it was going to be in by March 31st. We hit our deadline to disclose our alibi. And all of a sudden now they need to redo something in the report, which shocks me because of the things they said that they relied on were things that already existed. So now I really need to know what they're relying on to do this report. And I really need to see the analysis, and I really need to see the final report.
Sure.
I have to react to it.
Since we're talking about this, Ms. Jennings, do you want to just respond to that?
Hey.
Whether or not this is still
Miss Smith, I think you're still listening, but here we go. Now they're going to talk about the alibi. I bet they're going to talk about it now. She says, originally defense said he was driving that night, but would provide more info in camera. Then a few months ago, they provided a little more info, but they are still apprehensive. Right. Yeah, no, absolutely. Everything you're saying is fair, right? In other words, I mean, I don't know if shady is the right word, but yeah, apprehensive, right? Like that's a little bit like, from the defense, right? But it's understandable because, I mean, it might be hard to prove an alibi, right? Like, how do you, okay, how to say this? It might be tough to provide an alibi defense if there's not a really good alibi. And then that could explain it. But also, as we're gonna hear, I'm sure, it's tough because there's things that they're missing. And again, that's where the catch-22 comes in. I really can't wait to see what they say about this.
Progress or what's going on?
Right, Your Honor. As I know right now, that report is not in its final form. And it has gone through a peer review process. My understanding is it's still in that. I have been told that yes, it's not a matter of redoing anything, but as they receive additional information, they just want to double check their work. They want to make sure that when they get the final report, it's accurate. So we are still waiting for that final report to ensure that it's accurate. And as soon as we receive it.
I'm sorry. You have a time frame for that?
Right. Absolutely.
What we do.
I completely agree. I completely agree. Right. And that's what Judge has been saying, right? Because he's given them pushback previously when they were discussing the alibi about the reason for the alibi defense is not so you can wait until you get all the info, right? So I totally agree with that because she's saying, Miss Smith is saying, if defense knows BK was in a particular area at a specific time, they can present it to Judge, and then provide the supporting info once the state provides the report. Right. Yeah, no, absolutely. That's exactly what I was saying before. And like that's what Judge has said. So it'll be interesting to see
When they expect.
but like yeah, no, I mean, I guess it is hard. It is more of a stretch for me if I try to think about it. It is more of a stretch for me to see how they should need more information to provide the alibi. It is more of a stretch. I feel like they should, like if there's a good alibi, likely they can do. However, I understand from their perspective why they would want more information, right? Right. Yeah, absolutely.
That to be finished.
I don't have a final time frame. They originally told us it was projected to be completed by June next month. So I'm hoping to get it within the next month.
All right, thank you. Appreciate that. Sometimes it's easier just to sort a particular issue at the same time.
Some of the hot ones, it might be Your Honor.
Yeah.
Your Honor, I do think we have the regional tower list now, so I think we're good with that. On item number 244 and 245, we have those documents now, so we're good there.
Are you so when you say in camera, are you referring to also ex parte? Because they could be different things like I just don't know because you mentioned earlier ex parte. I just don't know if you're referring to the same instance or if you're referring to a different instance. But I don't know that they like in camera. I guess they're not really calling it in camera anymore. They're calling it like in terms of the languaging in the court documents, they're calling it closed or open in terms of the hearings. So that's kind of how I'm thinking of it, like closed, like for example, the IGG portion that happens this same day, May 30th, the end of the day was closed. So they cut off the cameras. So yeah, I don't really know let me look it up and see exactly how they would, if there's anything specific that matters there between closed and in camera for a hearing. Because I know that like for the closed portion, people still can't report on what was said, even though the cameras aren't on. Like it's not just about the cameras, in other words. Yeah, that's what I thought. So in camera, I'm pretty sure is more like during a trial. Or during a proceeding. So that's kind of what I had understood it to mean. That's what it looks like it's saying online. Right. Yeah, we hear so in camera we hear of we hear that more during trial or like there were a couple different Kohberger proceedings earlier on, like when they were doing like formal stuff, like again like a court proceeding that was not a hearing. And I feel like that maybe they did some in-camera stuff then because I do remember that term being used, but it's been a really long time. And ever since then, they've just had hearings, and so it's been closed or open. So, right, yeah, I know what ex parte means, but like, in other words, if it's ex parte, we wouldn't see it either, right? No one would see it, but they could. Like, the reason I just wanted to clarify is because something could still be in camera, but not ex parte, right? They could, like, both parties could be there and do something in camera. That's why I was clarifying. So, yeah, I don't know. I mean, Yeah, I'm not quite sure what you mean by that. Because, like, I don't know. Every time from everything I understand of in camera, it's, it's again, like typically during a trial or a court proceeding where it's, it's closed to the public. The judge just reviewing information, I feel like, he could do that in chambers, right? In his chambers at any point in time. Okay, yeah, right. Okay, that's right. That's what I thought, and I just wanted to be sure because I don't like to make assumptions because you know what they say about assumptions, right? I don't like to make assumptions. So that's what I figured, but that's what I wanted to make sure. It would be both. Okay, yep. Because you could have one, yeah. Cool. So we're on the same page with that. Yeah, I guess the only thing I'm confused about is the languaging because the in-camera thing to me, I'm not quite sure. Maybe it's just a particular thing I have not encountered. Right. Okay. So in family law, it looks like maybe, so I don't know, maybe it varies. It looks like this says that in family law, in camera is a private session with the judge, but like I'm only seeing that in relation to family law. So wow, apparently in camera is also used in terms of like board meetings at businesses. If for anyone, I didn't know that. It's not just used in law. Like they'll use, it says in camera, they'll use that even for like a confidential meeting when it comes to like a board at a corporation. That's wild. What the heck? Life is crazy. Right. So I see what you're saying. I guess the way I understand that is it would be yeah, ex parte, but I guess I would, in my mind, I'm still thinking of that in my brain as a closed ex parte hearing, like a closed hearing, ex parte. But yes. Did they call it in camera or did they call it closed? I mean, maybe this is sort of like what Judge was saying just a second ago in reference to the technology stuff, where and maybe what I've been saying too. We hear like I know, great example, like how we hear everyone talk about how his phone's on airplane mode, but that's not what it says. So I'm wondering if part of this could be that there's confusion because of the languaging, right? Like, I'm sure that there's people that said, "Oh, it's in camera," and probably other people, said it was closed. And that makes it confusing when you're like me and you're like, well, wait, these actually are actual things that mean different things. And as y'all know, being as I'm so inquisitive and I ask a million questions. And for me, it's not about correcting anything. I'm just like, well, wait, hang on. I want to actually know what things mean. Like, it's just the way I am. So, so then it becomes tricky when words get used interchangeably if they mean different things. I wonder if that's part of what's happening here. Because now that you mention it, I feel like I heard that referred to as both. Like, and when I say referred to, I'm talking about people again on like court TV, law and crime, or on podcasts, whatever the case may be. And I think it's just people just think I think there's maybe an understanding that if they use that language, whatever it is, people are going to understand it. Oh, they know what they mean, right? But like the problem is again, like these actually are different things. But if you want to elaborate in terms of like, what you mean by the in-camera part, feel free. But like, yeah, I just thinking about it, I remember them saying that, but I feel like I also remember people referring to it as like a closed hearing. And again, I'm still trying to be clear in my own mind on what the difference is, but again, like in camera seems to be broader because it can describe board meetings and shit as well. I wonder if this is what it is, and maybe this is where the confusion lies. Okay. I wonder if all closed hearings are in camera, but not all in camera is a closed hearing, in the sense that in camera can also refer to things outside of law, like a board meeting. I'm literally, y'all, I'm sure y'all are like, what the heck is the point of this? Like, this is just in my own brain. I have to get things straight. So, like, in camera, in other words, is the more broad term. So again, if it's like a closed hearing is also in camera, but not all in cameras are a closed hearing. I don't know if that makes any sense, but that's maybe what I am gleaning from trying to read about this online. Hopefully you guys appreciate that if I'm nothing if not thorough when it comes to this stuff.
Moving then to item 248. This is the drive test data, the mapping data. The court heard pretty extensively that we've received this in two places. We've received some early on, and then we received a lot more recently, but it appears to still be missing some. Asking the court just to order that we receive the entirety of all drive test data that was conducted by Agent Balance or anybody from the FBI. 249 is anything that exists after January 6th of 2023 for the drive test data. That's number 249. And so I would ask the court to order that to the extent that it exists. Would ask that it be ordered to be produced. Item 250 is the training and certification records for Nick Balance and Sean Kennedy relating specifically to the use of the Gladiator or the GAR. That's the item used to conduct these
Gar,
drive
make
tests.
a lot of pirate jokes there.
Your Honor, I think that we gave the court a transcript of testimony of Nick Balance that occurred within the last year. And that transcript had highlighting on it, so the court didn't have to read the whole thing, but to look at how many times the training and experience was relied upon by this expert, and that expert's Nick Balance. And if he's going to be a testifying expert, the discovery rules allow for us to have their training. We asked for it specific to this Gladiator because we know that's going to be a big part of his testimony. So we're asking the court to order that we receive his training and certification records relating to the GAR product. Similarly, now we'll talk about the GAR unit itself and its calibration records or its certificates that it's in compliance. The court just heard the testimony from Mr. Ray about how important that is, that often they get tired, things go wrong with them, and they get restored to service. We do have 2 certificates, but what we need is what Mr. Ray called the bookends, so we need the other side. We know that it came in non-compliant and then it was restored and went back out. We don't know what happened after it was used. We don't know the next bit of calibration that it went through. We don't know how it checked out. So we need the full copy, the bookend copy of the calibration reports.
That this is still in 250.
That one is 250. Yes. Sorry, Judge. I think that might have been in 251. That was in 251. 250 is the training records for the agents, and 251 is for the calibration records for the instrument. I apologize for that.
Oh yeah, the calibration. Yes, Ms. Smith saying in camera when a judge looks at evidence all by themselves without anyone watching. I'm sure it can include that. We've heard in camera used it's used in a lot of different ways. Like again, it can be used in terms of corporations having a board meeting that's private, like without, again, in camera from everything, it's like broader, right? And camera it says it's derivative of in a room, basically. Like that's what it means. It's like camera is like room. So in a room. So, yeah, I think that's where it could be something really specific, but it also is technically by definition, it can be broad. It is a broad term. And what else was I going to say about that? Yeah, I just remember, for example, just to give an example, beyond the whole thing about corporations and stuff that can have a board meeting in camera, in the Murdaugh trial, for example, there were a lot of things that were done in camera. That was the terminology used. I'm just being specific with the terminology. During the trial, they would say, we're going to go in camera and they would have like an in-camera hearing, which meant it was a closed hearing, but it was on the record, but all parties were there. And it was all the part, and like that was a lot of the stuff going on with like the jurors behind the scenes and Becky Hill and all that. So there were a lot of different people there. It was all the parties, other people, the judge, and it was on the record in terms of court record, the transcripts, but it was in camera is the terminology they used. So I guess that's part of like, just to give another example is, I guess, it can mean different things. So it's important to clarify,
Like 258 is a request for all information, all data, including all expert reports that the state has relied upon in developing the affidavits in support of all warrants.
That's like a big one.
It's a big one. And the state responded with an answer saying, these are the things that have been relied on. I'll tell you what my concern is, that there are things maybe in computer files, things on somebody's desk that haven't been turned over yet. So I think the court ought to order that the state make sure they've given us everything that was relied on for every single one of the warrants. Ms. Massa indicated to the court, and I know that other members, I think Mr. Logston has indicated that we're going to have motions to suppress. And so we want to make sure that we have all of the information. Possibly it would answer questions so we don't have to have this many. But
So we don't have to what?
have quite as many motions to suppress.
Okay, thank you.
That's not a problem.
I understand.
All right, Judge, let's talk about the fifth motion to compel. That completed the fourth. The fifth motion to compel, we are not going to talk about the 15th request for discovery until this afternoon. So my comments will relate to the supplemental request for discovery, number 12, number 13, and number 14. In request number 259, number 260, 261, 262, and 265, the state has let us know that these are coming. They responded on May 10th and said these are coming. They don't have a problem. So we're asking the court to order them to be disclosed to us. I think these are some that aren't going to be available for a while, but I think the court ought to order it. The state doesn't seem to have an objection to us having them. The order will mean we don't have to come back if something doesn't get through to us.
Okay, can you give me those numbers again, please?
Yes, I can. It's number 259, number 260, number 261, 262, and 265.
Thank you.
Your Honor, 289 related to communications between Detective Payne and the WSU officer talking about White Elantras. I believe that that's been covered. Payne testified today that we have the instant messages and there was only a phone call and that was it. So to the extent that that's the very end of it, then we're fine. And so I think we are on that one. Item number 299 is called a tips lead sheet. And that's something that's referenced during the course of in the discovery. We were asked for an example that was sent to the state. I'm just going to ask the court to order that be disclosed to us. Number 300 relates to emails, notes, and other communications. The state's responded with 3 separate AV files, and I'm going to ask the court just to order that they all be given to us. We may have them all, but I'm going to ask that the court just order that just to be sure that we have them. Well, Your Honor, I take that back. I spoke with Ms. Jennings, and I know there's one area. I'm not going to talk about the area, but I know there's still one area that we don't have. So I'm going to ask the court to order that all emails, notes, and communications be produced to us. Your Honor, the next item is the CAST certification and training for Nick Balance. And for many of the same reasons that we asked for that for the Gladiator, we need to have his training records. He's going to come in as an expert. The discovery rules cover this. You can see an example of him testifying as an expert in the transcript that I provided.
That's not covered by 250.
250 is the training related to the Gladiator specifically. This one is relating very specifically to his training for his CAST work and certification for his CAST work. Item 287 relates to a new expert, a blood spatter expert that the state is working with. We're told that that's going to be available in June. It doesn't seem that there's an objection. We'd ask the court to order that be provided to us once received by the state. Items 306, 309, and 308. The response from the state has been that we've now worked through the TUI process. That letter's been given to the FBI, and so we may get those by early June. So we ask the court to order that those be produced. I don't think the state's objecting to those. They just don't quite have them yet. Your Honor, 313. Those are the Department of Transportation cameras. We heard testimony about that last week, that there was a letter preserving still shots, but not any video was available.
I can't even get started on that. Y'all have heard me rant enough about that Department of Transportation. I can't.
So I think that that's been complied with to the extent that it can be complied with. 314 was the email communication, and we received that, so that's been complied with. 316 and 315, I believe, are also subject to the TUI letter, so would ask the court order those be provided as soon as they're received. And now moving on to request 317, 322, 319, 320, 321, 323, 320, and 324. And then picking back up with 302. Those are all surveillance camera items that we've requested. We're asking the court to order Moscow Police Department, as the custodian of these things in this case, to do an inventory of what's there. You heard last week that Detective Mowry said, I don't have the videos, those aren't my responsibility. You heard today Detective Payne said it's Mowry and FBI agents. So we take Mowry out of the equation. He says, I didn't do it. I can't tell you where these videos are. I don't know who the FBI agents are. So first, I think the court ought to order that be disclosed to me. The second offer was that I can go to the Moscow Police Department evidence room and go through hundreds of hours, thousands of hours of videotapes, and that's just not reasonable. These are videotapes that have been collected in the course of this investigation. You heard Detective Payne say that when he looked at cameras on South 95 and the other road, south of Moscow, on the date in question, and in conformance with what he alleged in his affidavit of probable cause to arrest Bryan, he looked at those videos and he didn't find a car. That screams stuff that's exculpatory to me. I need to know where these videos are. They were collected. The court can see that from the reports that we put in the packet of evidence. The court knows they've been collected.
This is potentially, in my mind, one of the biggest things so far with this, of like a important thing for the defense, like, you know, exculpatory evidence. I mean, that's what it, you know, whether it's just he got lucky with the cell towers, or, you know, there was something funny happening with the phone, or something happened to the video surveillance that where, you know, I guess because of the fact that, remember, like the state of Idaho doesn't have the, you know, the Department of Transportation doesn't have it. Now, having said that, it still remains that the businesses, the private businesses on that road, they have video from them and it didn't show the car. So, I mean, essentially what it boils down to, like I pointed it out earlier, but I'm just reviewing it for everybody and myself. The car and the phone appear to not be together at this point in time, right? After the murders. That's the thing. That's what it boils down to, because it looks like the cell phone is on I-95 and the car is not. So that's a lot to work with. I mean, that's a lot to work with. I mean, it'll be interesting to see what else happens with this, but like, that's a big deal. So,
But nobody can tell me where they, and I need to help. I don't physically have time to go watch thousands of hours in Moscow Police Department and be efficient with the case. But if that's what I have to do, I guess I need the court to tell me that's what I have to do. I think you have the ability to order that there be an accounting of all of these videos. Keep in mind what we heard today was exculpatory. So there has to be a duty to categorize all of these videos and get that information to me. Go find these videos that other police officers turned over to Moscow Police Department that are in relevant areas. That's just critical, and that needs to happen.
So I did look at a long list of videos that were provided to the defense that said there was nothing there, or his camera was broken, or so there was some kind of inventory there. I mean, you saw that, right?
Yes.
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 Okay. So what you want now is just a complete inventory of all of the videos that they obtained.
That would be appropriate to have that, but there are specifically named videos in this fifth motion to compel that we specifically want the videos. We know they're there. We've read the police report.
Okay,
We've given
and if these 317 through, I don't know, 324, you're saying that those are specific
there's a
videos that you want, that you know, or you think you know, are in this inventory.
Well, I don't know if they're in that inventory. I don't have them. I know they were collected and given to Moscow Police Department. I want to know where they are. And we listed out in 317, in 322, 319, 320, 321, 323, and 324 different locations that say we collected these. We gave them to Moscow Police Department. That's what I need to know. Where are they?
You didn't get any of these videos of this list that you just gave me.
No, of that list I gave you, I did not. There was also one that I asked to be included.
Yeah. His face.
Coming back to that number. It's 302. We did get a time frame on the day before the incident. And so I need to know where the time frame after the incident is.
Okay.
Okay.
Thank you.
Thank you, Judge, for that. And I'm close to being done. Number 325. The answer was that if there was communications, it would have been a call. So that one's fine. We're good with that one. Number 326 is Uber logs between Detective Mallory and the Uber company. They've been provided to us, but I can't get into them. They're password protected. Miss Jennings and I have been trying to work that out. I think she'll continue to try to help me, but to the extent that it doesn't work, I'll need a copy that does log in some form. And I think the rest of them, 335, 336, 337, 338, and 339, the state has indicated that we've been given everything there is and nothing else exists. This all has to do with vehicle identification, and we're talking about identifying a car in question from a video as being a 2011 to 13 Elantra.
Back to the car.
They say we have it all. So if we have it all, that's great. I just don't want any surprises.
You know what's wild, y'all? This whole thing started with the White Elantra, right? Like in terms of like after the murders, like, I mean, no one knew what happened, like who did it or whatever. And like the first thing that we heard of, and it seems like the first lead for them as well. It was the White Elantra, right? That's what like all this was based on. It was the White Elantra. And so isn't it going to be so interesting if like the real linchpin that in terms of what needs to be proven, like what, like, and I, okay, how to phrase it? Like, what if it comes down to, it all started with the White Elantra, but like the thing that's tricky for the state is where did the White Elantra go, right? Afterwards. Because it's not with a cell phone. And it's like the missing White Elantra. You know what I mean? Like, I don't know. It's almost like, I'm just thinking from like a, what's the way to say it? Almost like a poetic side of things, right? There's just the sense that like it all started with the White Elantra, but then, you know, it could end with what happened to the White Elantra. And that's the thing that needs to be, that could be the mystery. You know, like think of it like Murdaugh. I always compare, you know, where, you know, the prosecution couldn't answer every question, right? Like in terms of the full ins and outs of all these details, and they don't have to, that's not their job, right? But there were loops that were just kind of not entirely closed or things they couldn't really explain. And that's what we kind of worked on during our deep dive. And I think we figured out a lot of stuff. But I guess my thought is like that White Elantra on the way back afterwards, you know, could be that type of deal for the prosecution, potentially, right? We know it's way too early to say, but I'm just thinking theoretically about it.
Again, Your Honor, and we think the court should order the things as we outline. They are material to the preparation of our defense. I would remind the court that relevance is the standard of whether it gets in front of the jury, but it's a different standard when we're talking about materiality. That was talked about in the Pendleton case, and I know the court's familiar with the Pendleton case. The court wrote about that in a previous order.
Yes.
So I'll leave it at that and just request that the court order these things so we can
I'm at that list at the end about the identification of vehicle. You're saying that they have provided that to you, but they're telling you that's all they have.
Yes, there are specific items that they say, we gave you everything that's there. The rest of these items don't exist. It has to do with cameras and camera angles and different things like that. It's spelled out in the fifth motion to compel.
Okay.
I just don't want to be surprised.
You just want to make sure that if they find something else, they provide some supplemental response.
Well, I'd be concerned if they find something else after
Right.
they said nothing
Well,
else exists.
they're shaking their heads right now, but you never know. So, okay. Thank you very much.
Thank you, Judge.
Ms. Jennings,
Thank you, Judge.
it's a lot of stuff there.
Yes, and I'll try to make this quick. Kind of go through each of these items that are still out there.
They do call it a sedan. They do. Yes, they do. Let me pull it up. They do. And I was reading from that. I'll pull it up again. What I'm going to do also, I've already kind of made an executive decision because I keep toying around with the idea. I just need to do it. I'm going to do a review of this, and I'm going to do it in a way where I break it down the way I kind of Murdaugh style, where we go through it piece by piece and we work it out. Like, you know, for example, we can pull up all the maps and look at all this stuff. So let me pull up what you're asking about with the car. They do refer to it as a sedan. Let me see if they call it They don't. Let me find that part. Hold on. Instead of me guessing or trying to remember, let me just find it. So initially they refer to suspect vehicle 1 a whole ton, right? But that's before they established what the vehicle is, which is what's interesting. So suspect vehicle 1 is referred to from the very beginning of the affidavit all the way through. You know what? I just had a thought. I wonder if that's the thing from a while ago that the other lady for the defense, Miss Massoff, back when she was arguing. Remember when I replayed it a couple times because I was like, what's she referring to? She said it's in the PCA. She was saying something that was a return on a subpoena or a search warrant, rather, that was used as in the PCA. I wonder if that thing is the car, because here's why. Because of what I just said. From the very beginning, they refer to suspect vehicle 1 all the way through, but they're calling it that before they've identified the vehicle and that the vehicle has any connection to Bryan Kohberger. I can see how that's a problem. And then they would have used that vehicle. Yeah, I can see that. Like that I wonder if that's part of it because they hadn't identified it yet. Hold on, let me keep reading here. Law enforcement officers provided video footage of suspect vehicle 1 to forensic examiners with the FBI. We read that part earlier. He looked at it, blah, blah, blah. After reviewing numerous observations of suspect vehicle 1, the forensic examiner initially believed that the suspect vehicle 1 was a 2011 and 2013 Elantra. So that's where he identifies it. So I think what you're asking, though, is like when it's first referred to. Let me go back to the very beginning again. There's a lot of things that are kind of read weirdly about this to me in a way. Because it's like cart before the horse. Like as I'm reading through it, I'm like, they're saying these things like just even again with shit like with the vehicle, right? Where they're like calling it a name, but they hadn't learned that at the time. You see what I mean? Like it's like, I don't know. Like in other affidavits and stuff, what they'll say is like, which I later learned was blah, 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 right? Like they'll be like, if they're referring to something that they don't know what it is at the time when they're because they're describing events that happen in order, right? In these things, in chronological order. Usually what'll happen is if they're referring to something that's happening like contemporaneously, and then they later learn what something is, they'll be like the blah, blah, but then they'll be like, which I later learned was this thing, right? That language is not in here. And I think that's one of the things that seems weird to me. Okay. I'm going back through again. I'm going to look for the very first time a vehicle. Actually, I have a better idea. I'm going to control F myself, as EDB would say. We're going to do vehicle. Let's do this. We're going to do all the keywords and see if it'll find when it first comes up. All right. The word vehicle is first used. And actually, I read this part earlier in the stream. The word vehicle is first used when it says on page 5, a review of camera footage indicated that a white sedan here and after suspect vehicle 1. So they called it, I think that's answering your question. They called it a white sedan. So okay, let me read that again. A review of camera footage indicated that a white sedan hereafter suspect vehicle 1 was observed traveling westbound in the 700 block of Indian Hills Drive in Moscow at approximately 3:26 a.m. And I actually read this part and had it pulled up on the screen earlier in this live stream. So we did read that, but we were looking for something else at the time. I think maybe the maps. So they refer to it as a white sedan hereafter suspect vehicle 1. So let me see what you're saying. Because in a way that makes sense because they hadn't consulted with the FBI at that point to have it identified as an Elantra. Okay, glad you like that idea. Yeah, again, I don't know that it was. I would have to go back through and the timelines. Yeah, I'd have to go through and put all the statements against each other and go through all that. Yeah, and when the eyebrows, that's in the affidavit. But yeah. Now, one thing though is, in regards to the, I sound like Wally, the communications between the roommates, right? Now we know that again, they were using some of those records in order to extend the scope of the search warrant for BK, which means again, I said it before, I'll say it, there must have been something where that connected him to their, like they were, which is what's crazy, right? However, if it happened that the roommates talked to each other before the police and texted about it or whatever, and maybe mentioned the Bush, like that would come out at the trial. That would come out. The prosecution would definitely present that. Um, Yeah, it's been, yeah, I don't know if you've been following, I don't know if you've been here when we've been doing the recaps for Karen Reed, but it's so funny. And I've been doing Karen Reed so much, which is so funny. I never planned on watching or covering that trial. I didn't know anything about it till opening statements. And I've been doing the recaps, but I've also been streaming it live a lot. I'm actually going to be doing it tomorrow morning. Well, it's today now, but as long as I possibly can. And then I'm going to do a recap as well. So it's a lot of hours. I've been doing a lot. I've spent a lot of hours a day with Wally right now. Okay, guys. And it is what it is. And I found that I'm not the only one where I'm like, it's just from hearing him so much. And he uses the same words that I'm like saying in reference to, in regards to. And I think I've even picked up saying every now and again, like, what if any, like, oh my God, it's like, no, Runkle calls it the Canton brainworm. And he uses it in reference to, see, I was going to say it. And then I was like, fuck. He uses it for like, all of a sudden, like, oh, I can't remember. But I think the Canton brainworm needs to be extended to Lolly. Like, it's like Lolly's the Canton brainworm. Like Lolly, and that it talks the same way over and over again. And then it just becomes like people just start doing it. Like we've heard it from even the defense attorneys a couple of times. Which is really funny. So yeah.
For discussion, but just to give you a little bit of perspective of what all has been provided to date.
I think it's interesting. I'm just going to note, I don't, it doesn't mean anything, but like Ann Taylor and same with Miss Masseth, whenever they were speaking, they came over to the podium. It's interesting that Ms. Jennings is staying right there. I don't know why. It seems like, I'm not saying she should go to the podium. It's just funny that they're not doing the same thing, right? Because like court, usually it's like there's rules, right? It's just interesting. I guess it's just interesting that they're not both doing the same thing. That's all. I know, right? Oh my God, right? Yeah.
Well, I rest assured, both sides, that I have gone through page after page after page after page. So, yeah, I understand. I have some perspective about what's been going on and how hard both sides have been working. So,
and just to give a little context, why this isn't just so simple. To date, we've given 15,691 bait stamped pages of discovery. So, for a little context, this is
she was sitting.
It would be about 39 of these.
She was sitting initially for the first part, or I guess it was during the testimony, maybe when she was cross-examining. She was definitely sitting before, which I noticed as well. And Ann Taylor always goes to the podium.
Given 13,758 bait stamped photographs. That's about 34 of those binders of photographs. We've given 911 AV dumps. Those are digital files. In addition to a massive hard drive, about 50 terabytes full of discovery. And that includes audio, video from about 285 interviews, 15,000 video clips from approximately 79 businesses, 8,000 video clips from approximately 10 residences, 417 files containing call detail records, multiple terabytes of records for 11 computer devices, 17 cell phones, multiple social media accounts, and 4 tower dumps.
Ms. Jennings.
4 tower dumps. In addition to records regarding well over 17,000 tips. We've given multiple terabytes of records in response to the 71 grand jury subpoenas, as well as the 101 search warrants that were done in this case. We have facilitated the defense viewing the physical evidence on multiple occasions, as well as facilitated additional DNA trace evidence to be examined at their request. We've had a consistent pattern of loading up discovery and providing a hard drive to the defense on an almost weekly basis. And just to be clear, we're going to continue to do that. As we receive discovery, we review it, we load it on our hard drive, and we give it over. Now, going specifically through each of the requests, we've already dealt with in the fourth motion to compel. Item 214, we've already argued. The CAS biz logs. We heard the testimony, and what we know and what the judge heard testimony for is that CAS biz is just a software program. It allows investigators to put in like the records received from a cell phone provider like AT&T into a software program, and they kind of visualize. Detective Mallory testified he got the raw data set from AT&T, used the default settings for the times in question. It produced a map. He took a screenshot of that map. We provided that screenshot. He only did this in response to our request to provide a visual for the grand jury. We've been told that optional session files were not created or saved, and that this item just simply doesn't exist. In the current version of CAS-Viz, the user settings aren't automatically saved in an exported session, but instead it just returns to default settings. I asked Detective Mallory about this. He advised us that he used the default settings. It doesn't take much time or effort to redo this, which is why he didn't save those logs. That's his normal practice. He just saved the screenshots, and we've provided that. We agree, we will double check. We're doing that throughout all of this. To our knowledge, there are not tower documents that were relied upon, but we will double check and inquire, and if that exists, then we will turn it over. 226 has to do, well, first the request was for the
Right. I couldn't agree more. Ms. Smith says all this data is great, but if it doesn't provide relevant time area data, the state is basically bearing them data. Absolutely. And the problem, like, that was a huge problem that we heard from the testimony portion last time about how nothing is labeled. He's like, yep. She's like, so you're telling me you've got all these videos and there's not a sticky note, there's not a thumb drive, and you don't know what's on what, and blah, blah. And as she's saying it, you're like, that sounds ridiculous. And he's like, yep. And it's like, wow, you're an asshole, first of all. And like, second of all, what the fuck? Because it's like, how the hell do you expect anybody to benefit from those, including the state, if they're not organized? So yeah, I mean, I totally agree. Right. I know. I agree. That's exactly what it is. That's well said.
AT&T Hemisphere program.
Accurate.
And then it detailed several other things below it. And we were told they didn't use the Hemisphere program. And you're right, language is important as to exactly what's being requested. And now after a series of back and forth, they're saying that they want AT&T timing report. We have been told if that's referring to timing advance records, those records don't exist. We do have these location records, the DBOR records, and we've given those over. Now, the second part, it says that investigators recently obtained certified records from AT&T, and that'll be disclosed in upcoming discovery production. My understanding is that that's not related to the above. It's not related to Bryan Kohberger's records. It's related to other records that were done later for other folks. But we will be providing that in the next production doc. Next is 228, complete copy of all materials relied upon Corporal Payne. To our knowledge, we turned all of that over. We have given the documentation of correspondence between our cast agent Balance as well as with Detective Payne. And he testified today that the only other communication, they were together. So they were just relaying things verbally. And then he was including that information in his report. Now we're at 242, a complete cast report. We've already discussed that.
When you say complied with, does that mean that both sides agree that it was complied with? Or is it that you saying that you complied with that, but they are still asking for it? I just want to, speaking of language.
Well, I can't speak for the defense, but to our knowledge, we have provided everything that relates to the made data.
Okay. No, I just want to be clear about that. So if both sides agree that this is done, we don't need to keep arguing about this. But if the state is saying, well, we've complied, but they don't agree with that, then that's something that I have to deal with. Ms. Taylor.
Your Honor, there's so much here. So the clarification on this is they did give us MAID data. I've been working with our expert and we think that all the data is there, but part 2 of it has to do with the Babel information that's coming. That's in the 5th motion to compel. And
That's a great
good one to remember. Yeah.
Yes.
And so I need that to put those 2 together. So I think the MAID data we have, I need to reserve though and say once our experts had full time to look at the MAID data, once we get the Babel stuff as well, then we may have a problem. But they did do a disclosure. For sure they did do a disclosure. I just can't say it's.
Are they saying Babel? They've said this word a lot. I think it sounds like they're saying Babel, but I'm like Babel, like as in the language company. Like I don't know why that would be involved, but I don't know. Maybe they're saying battle, but it sounds like Babel.
What we were looking for quite yet.
All right. So some of these we might come back to me to say, okay, where there's something missing or everything's fine.
And I will speak with Ms. Jensen if I notice that ahead of time too.
Okay, thank you.
243 relates to the final draft of the past report. 244 is done. 248, there's still some questions about. I will say that Ms. Taylor reached out to me last week, letting me know that they believe there might be some missing pieces there. I reached out to SA Balance, asking. He was at a training all last week. I've been told he's looking into it to see if there is additional information. Then, of course, we would produce that. That's all I know at this point. And 258. Again, this is a very broad request. If there's something specifically that they're looking for, that would be helpful. But as far as the state's concerned, we've complied with this request. We've given you.
Again, though, it's like, well, Ann Taylor's argued this before at it was at a different hearing. Like it was from 2 hearings ago, where she said that like the problem is that we don't know what we need till we see it. Like in terms of exculpatory evidence, right? It's like, I think how did she say it before? Like, okay, the defense is required to turn over all exculpatory evidence, right? But there's another catch, which is they might see something and not know that it's exculpatory or view it as exculpatory. I mean, in other words, it might not be like a willful Brady violation, right? But, so you don't know until you look through it, right? I mean, how many times, even think of like any investigator that we've heard of or detective and like a cold case, right? Where it's like they've poured through these documents and these pictures and the evidence, for decades sometimes, right? And, let's leave technology developments out of it because that's a whole different thing. But just in terms of just someone getting a third opinion or another set of eyes or whatever, that type of thing, right? Another fresh look. And how many cases do we hear about where it's like decades later and they catch something that seemed negligible and everybody overlooked it, right? It was and they caught it and they're like, wait, did we ever look into this? And, and sure enough, that's the thing. That happens so oftentimes with these cases. And that's just an example of like, you don't know what you need to know until you know what I mean? Like, so it's tough. It's tough. Like I understand why, but that's why they need to just turn it all over, right?
The returns for all of the 100
they should turn it over and they should make sure it's organized. I feel like.
Search warrants that were done, as well as the affidavits, which detail exactly what the investigator relied upon in order to obtain those search warrants. Again, if there is something specific that they're seeking or looking for, if they can provide that to us, then we will inquire. Now we move on to the 5th. Items 259 through Well, 259, 260, 261, 262, and 265. Yes, our answer is that we have inquired. We've been told that this is coming. The employee responsible for these items is out on medical leave for about 6 to 8 weeks. We still have probably another month left before she returns. And then would need time for that to be completed. But we do intend on giving this over. As we've done already, as we get it, we turn it over.
That seems kind of surprising. I feel like if you have an important role in a government agency, I just find it really hard to believe that there's just one person on the job. Or if that person's out on medical leave, that job doesn't function. Like, I feel like I just don't, it doesn't seem really all that plausible. You know, that like there's not somebody else doing her job while she's gone. Like, I don't know. Like, that just doesn't seem smart, right? To have like only one person that can do a job when it's an important job anywhere, but especially when it comes to like the government, right? Where everybody's got a role that they do, and they're not going to have typically any roles that aren't necessary, right? Every role is going to be important because, you know, trying to, you know, taxpayer dollars and whatnot. Anyway, it's just, I don't know, it's interesting.
299, temp lead sheets.
Right.
State has provided information for well over 17,000 tips in this case.
Right. Yeah.
We've been advised by the FBI.
God forbid she doesn't come back. Yeah. If she doesn't come back, then it's just, I guess we're screwed. Like, that job is never happening ever again. We're never getting those records. I mean, for real. That's so silly.
That they believe they have provided all information related to tips. Now, I'm unsure if there are duplicates of the same information. We will inquire, but substantively, it's our understanding that they have all the information for the 17,000 tips. But yes, I will inquire and see if there's a tip lead sheet that can be easily provided. 300, this has, for the majority, already been provided. They already have the ISP and PD emails. I've talked to Ms. Taylor about another certain section of emails that she would like to see. I will inquire about that, and if they exist, we will turn them over. 263 and 264 have to do with CAS certification and training records. I can tell the court we're going to comply with this. We're not at our expert discovery disclosure deadline, and we're just not at that point, but we will be. And we plan on giving this over on anything we intend to rely upon. 274, 275, 278 have all been done. 287, this is an expert analysis. We haven't received it. We are expecting to receive it sometime in the next month. As soon as we receive that, we will discover. And starting with 302 is when we get into all these different surveillance videos. We have provided them a list of all of the videos as they're labeled and as they're stored at MPD. Now, yes, we will do our due diligence to make sure that what we have is turned over. To date, though, and we'll continue to do that. To date, we have located a Watson Carey construction video, but the only thing we've located is one that covers from about 9 p.m. on the 12th till midnight. We'll continue to look for what they've requested, and as soon as, if it's located, we will turn it over. Next series, 306, 307, 308, 309 are all part of the 2-week process. As detailed in our response, we've been told by the FBI that it's going through their process, and we're hoping to hear something back about whether or not these are approved and when they're going to be provided in early June. Back to videos 317. The first thing they asked for is this U.S. Bank video. That's been provided. Ampersand, To our knowledge, it doesn't exist. Again, we'll do our due diligence to make sure. If it's located, we'll provide it. One World Cafe does not exist. And 9 to 5 is actually US Bank, and that's been provided. Red Star Coffee, we have, and 319, 320, 321 are all ones that are still outstanding. We'll continue to try to locate those. If they exist, we'll turn them over. 324, 325, 326 have all been complied with. 334 does not exist, and there will be a supplemental report to that effect. 335, 336, 337, 338, 339, 340 have all been complied with, and that gets us to the end of the 5th for this hearing.
Thank you. Any response?
Your Honor, just really briefly, I want to talk about item 226, the Hemisphere program. Ms. Jennings asked me if we meant the timing advance program. That's one and the same. I just heard her say that those records don't exist. I just need to be clear, if they don't exist, then I need to know that. If they do exist and they were used, I need to have them. She mentioned that item 250, that's the balance training records that we had. That we don't have that. That's balance training records related to the use of the Gladiator machine. We don't have those. 251 is partially complied with. That's the certificate on whether the Gladiator machine was working appropriately. We need the follow-up the next time that machine was put back for testing. Both machines, there were 2. 263 and 264, Balance and Kennedy's cast training records. I'm happy to hear that I'm going to get those. With regard to the videos on exhibit RR that the court has under number 21, this is where the business said they already had given over their videos, and Ampersand and One World Cafe are both listed on that as well. So they were given to somebody to go to Moscow Police Department at some point in time. And that's it for clarifications for me. Thank you.
Great. Excellent. Anything else?
No.
Okay, great. All right. A lot of work there for all of you. Maybe a lot, but why don't we take a break? And we're supposed to start the second chapter here. Why don't we start at 2:00? That's okay. All right. So we'll recess. Thank you.
And that's it. Now they are going to go talk about IGG. So I hope it all went well. Let me take my banner down here. Boop, boop, boop. Okay. Yeah. So I think this will be a good plan to go through the PCA and do like some mapping. I'm not sure yet if I'm going to do it in a live or like a video, like a regular video where I have it just like, do like a live premiere. I'm not sure yet. I'll have to think about it. But I think I'll definitely do that because I've been toying with the idea, and I think there was just plenty going on. Not to mention, for fuck's sake, like we need to look at actual maps that don't suck. That's so insane, man. I can't even believe that to include that in there is just wild to me. Like, oh my God. So it'll be nice to take a real map and put it into context, right? And take a look at some of that stuff. So, all right, but we do already have a good plan going forward for the next couple of days. Like I said, here in like less than 9 hours, I guess, I will be streaming the Karen Read trial. We don't know who's up next. It'll be a surprise. You know, jury's still out on if Trooper Proctor, or as Jen McCabe calls him, Proctor Trooper, Trooper Proctor, Proctor Trooper, if he's going to be taking the stand or not. We'll see. And then will there be any evidence? Just let's ask Lolly real quick what he thinks.
There's no evidence of anything in this case.
Right. Thank you, Lolly. I almost forgot. And then tomorrow night, I'm going to do the week recap for week 5. It'll be the only recap that so far where it's just 1 week is 1 episode, because there was only 1 day of court. And actually, the beginning portion of week 5, the 1 day, we already covered because we grouped that in with Brian Higgins. So what we will be covering in the week 5 recap is going to be everybody else. So it's going to be the ER doctor and the pathologist, and then the people who tested the blood alcohol level and all that stuff. It won't be a long one or anything, but we'll just go through that. There's some good information in there. I don't know that it's relevant to this case at all. I mean, finally, it's established that John O'Keefe died, so that's important. We learn a little bit more about the hypothermia and stuff like that, but I think that some of the most interesting stuff to me actually came from, again, it's really not even all that relevant. It was really more like background on how it works with people's, like, how they, like, it was the dude who talked about, I can't remember his name, but the dude who was just talking about, like, how it works with, like, the alcohol and stuff. Like, it's just interesting. Yuri Buchanan. Yeah. All I can say is, from what I understand, his name is either from, like, Ukrainian or Russian, like, heritage. I don't know anything about him, and I'm not doing any outside research. However, I would just love it if he, like, came in and had a really thick accent and spoke in Russian or Ukrainian and not English. Not that that's ever going to happen, but it would just be wishful thinking. Yes, Roberts, correct. That was the fellow. Yes, I think so. Roberts. Yeah, the guy. I liked that guy, and he was actually the only one we could hear at the end of that second half of the day. It was like, what? It was so refreshing. The pace was completely different, and the information was just really interesting to me. I felt like we just learn a lot from him about how it works with, like, how people process alcohol, and it was just good information that, I love to learn. So I was like, all right, I mean, I don't know why they needed to charge anybody with murder if they just wanted to prove a DUI case. But if that's what they wanted to do, they could have just started with the DUI evidence right off the bat, So, again, is it really that important? Like, I would rather be hearing at this point, it's like, I feel like they need to do more about proving what happened to John O'Keefe. And then, like, that's what we've seen in other cases where they do these charges like that, where there's, like, some other bullshit charge besides, like, murder. They always do that last, right? It's like, oh, by the way, also this. But, like, they prove all the important shit first. This is just so silly. So, but however, having said that, if Wally wants to, like, that's how he wants to spend his time in a way that makes no sense, and where everything is like backwards day and Twilight Zone, you know what? I'm happy he finally called someone to the stand who you can actually hear them. They speak in sentences, and they actually are talking at a normal pace and giving interesting information. I'm like, hallelujah. Thank goodness for this, right? So that'll probably be some of the highlight of the week 5 recap. That'll happen tomorrow night. Tuesday, there's no court. And I think that Tuesday, I don't have anything scheduled yet. Wednesday, I think I'm going to try to live stream court again. And then I'm also going to try to start recapping week 6 on Wednesday. It might be a bit ambitious. We'll see. It also just kind of depends on what happens too, right? And who comes up and takes a stand. But that's the tentative plan. So I think there's like, what, three or four things already on the books for this week scheduled. Anywho, for anyone who is not familiar, highly recommend the Law Squirrel Discord, because A, we have a lot of fun, and B, you will get notifications for upcoming videos there as well, because now that we're talking about schedule, because sometimes, YouTube notifications, as we all know, they can be hit or miss. So the Discord is really fun, and also we'll make sure that you're kept up to speed. Right. Yes. Which makes sense. And I don't know. I mean, fuck. I'll be honest with y'all. I don't know that I even really care. Like, if this was normal life and they'd already gone through and dealt with all the other stuff that matters with actual evidence, then maybe I would think, okay, let's scrutinize if it was garbage in or you know what I mean? Like, was it tested appropriately? Were there flaws? Like, in other words, that's what's going to come down to, right? With this blood alcohol level. It's like all these factors, like, I don't know. Can was it done? Like when they were talking, they went on and on about you not using an alcohol swab to clean the area before you do the phlebotomy. And it's just like, why is this what we're talking about right now? Like, again, if you've proved everything else and you're just like, have nothing else left, sure, let's examine whether or not the very last minute detail of this was done properly. But at this point, I'm just like, honestly, I don't even like, I don't care right now about like, all the little minute details of the collection of the blood for the phlebotomy, for the thing. You know what I mean? It's like, I don't, honestly, to me, it's like her blood, like that's besides the point. We're still trying to figure out anything about what happened to the victim. Like, come on now. Yeah. Oh yeah. It's got to be hard too, because the rhythm of life is so weird. Like, I feel like it would almost be more appreciated in a way if it was the same every day. Like, even if they left early every day, like at 4:00, say, because most, this court's not normal. Most courts are going until 5:00. Sometimes they go over. They stay late if they need to, right? But this court, no such thing. But let's say they stopped at 4 every day, or like, even if they just stopped at 3 every day and did like a semi half day. But like, if it was the same every day, I feel like as a juror, that would be helpful, at least for me, like, because it's got to be hard. Like, what's got to be jarring, I would imagine, is because their life is not normal. They can't talk about their life. Right now, their life is trial and they can't talk about it to anybody. And one thing I've always wondered, and I don't know an answer to this, and I'd love to know an answer. I always think to myself, can they talk to a therapist? I don't think they can. I've thought about this a lot. I don't think they can, but I've always thought about, like, in cases where there was extremely graphic images. We know, for example, in the Lori Vallow trial, the jurors were like really struggling. They had to take several breaks during those pictures. I think somebody threw up. They were like, it was like so in my, but I know it's like they're not supposed to talk to anybody. However, I always think about that because the mental health impact that could take, like we ask so much of a jury, right? In terms of their time and their attention and all kinds of things, right? Like we ask so much of them. So for me, where I think we have to be careful is if we ask so much that they sacrifice their mental health to an extent that is not reasonable, right? Or healthy. Because obviously it's going to be hard. We know that. But like, it could be like, I guess in my mind, what I'm imagining is a lot of times that stuff comes up early on in trial to where it's going to be weeks before it's over. And I understand once it's over, of course you can talk to a therapist, but it's like, that's not the thing though, right? It's like, if you are going through, just imagine some of the shit that they hear and the shit that they see. It's hard to imagine how you come home after that day and you cannot talk to your partner or your spouse or your son or your daughter or whoever about why you're crying and why you're whatever you are. And you can't talk about what you can't, and then add to that, you can't even talk to a therapist when for some people it could be really traumatic. And I know they kind of feel that out with voir dire, but I don't know. I always think about that. Like, I feel like they should be able to talk to a therapist. Not that they're going to give specifics about the case, right? It's not about that, but that's, no one cares what I think, but yeah, that's a good point. But yeah, as far as the schedule is concerned, but yeah, so for me, I guess that's why I would find it jarring, right? Where it's like, in a way, it will almost be easier to get into the habit of like not going back into normal life. Like, I always think to myself, even with normal trials that are like Monday through Friday all day, I always think to myself, man, it must be jarring for them when it's the weekend. Because even just watching it feels jarring in a way. Like on the weekends, you're like, what's happening? There's not trial, So yeah, because it's like they can't really resume normal life. So if yeah, I can the days off and the half days and stuff might feel weird. But for some people, maybe they can jump right back into normal life. I don't know. I wouldn't be one to do that. I would be just wanting to get back to court. Yeah, and I think I've heard that as well. But see, I worry about during the trial. That's the thing, because they cannot talk to anybody about it. It's like after the trial, like providing all these resources after trial is great, and that should be done. But like sometimes the damages are like with trauma, sometimes the damage is already done. You know what I mean? It's like you can't just like throw a bunch of stuff at it after the fact and then erase damage that was done before that, right? Like, of course, you want to provide that stuff. They should, but I guess that's just where I get concerned because we just asked so much of our jurors already, you know? Right. Yeah. That's what I was saying. Like, I know, but having said that, also, you know, this is where my lawyer brain kicks in, right? Because I can all see both sides. I'm thinking to myself, yeah, I mean, they do voir dire, but also thinking back and forth, right? Like, a lot of people have never seen that kind of stuff before. And it's also got to be hard to anticipate how you're going to react. Like, you might think in theory that you can handle it. I mean, I don't know. It's just, it always blows my mind when you do hear from the jurors after the fact and they talk about being a juror, and it's just like they seem like such normal people, and I'm like, how the hell were they able to, you know? Because it's so sometimes it's almost worse not seeing it in a way too, though, because we hear about it, but we don't see it. I mean, I don't know what's worse. It's all bad, right? But you know, right? That's a good point. That's a good point. Yeah. And I feel like that has happened before. I feel like I've seen that happen in a couple trials where it did seem like somebody was removed for mental health reasons. But of course, they're not going to, you know, it's not going to come out at the time, like if they already had mental health issues or if it was related to the trial. But yeah, that's a good point. So yeah, but at least there's more court this week. So that Tuesday is the day off. Monday and Wednesday are full days. Thursday's a half day. Let me pull it up. And I think there's no court Friday. It's so funny because it's still like compared to normal court, like normal trials, is like it's like nothing. But compared to last week, it's more court. So let me pull it up. Yep, no court Tuesday or Friday. It's wild, right? Like normal trial, if there's just one day off randomly in the middle of the week, you're like, what the heck? Insane. No court Tuesday or Friday. And the other thing that's weird is their lunch schedule is weird because they like, you know, they end the day earlier, but then they get like this, like, what does she say? They're going to be shortening the lunches to 45 minutes. Like, what? 45 minutes? Wild to me. I mean, I would so much rather go to 5 o'clock and take a 2 hour or a 1 hour, you know, a longer, what, an hour and a half? Like usually they get an hour and a half or 2 hours. I think it's usually 2 hours. But I'm thinking in this case if she's trying to run a tight ship, like, you know, and where she wants 45 minutes, I feel like I would just be like, can we stay longer and take an hour and a half? But yeah, exactly. Yeah, no, the jury, they dedicate so much. What we ask of them is so much. So, it's hard to even comprehend that the lasting effects and, you know, it's wild. But yeah, so I don't know, man, like 45 minutes for lunch is insane. What trial was it? I think it was the Maya Kowalski trial. I don't know if you guys watched that. I think it was that trial. But they were so timely. It was insane. I've never seen that before. Like where was it that? No, wait. I'm trying to think. Maybe it was Dutt v. Heard. I don't know. Maybe it was both. But there's been a couple trials where like the court is like okay, we're going to take an 8-minute recess or something like that, where it's like a different number than usual. And it's like literally 8 minutes on the dot. Like they even bring the jurors in prior, and it's like, you're looking at it and you're like, holy crap, right? How did they manage that? Or even like the lunch hour, however long they take, it's like exactly on the dot. And it's like, wow, it's so, that's so unique for courts because usually they're always behind. Yeah, I know. Pre-rebuttal is right. Pre-rebuttal is right. Yeah. I mean, we're already on week 6. This is going to be week 6. Yeah, it's insane because the like, y'all, I've watched a lot of trials, man. I will just say I've watched a lot of trials, and I've done a lot of studying on shit. And like, I have heard it. We heard it even in Murdaugh. Just again, a recent example that I know most people that are watching may have watched because I covered it, right? Of course, but you could look at most trials, any trials, except for this trial, Karen Reed, like where, but there's with Murdaugh, I've watched that trial enough times to where in the entirety of a trial, there's things that I could actually find it on the day. Like it's insane. Like I can point to where this thing was said. And this would be an example where it's towards the end of the trial, and it's the defense's case in chief. No, sorry. It's the prosecution but they're getting ready to go into the defense case in chief. And it's a similar thing where Creighton wants to offer something, and they're arguing over it or whatever. And Judge Newman is like, no, that's pre-rebuttal. You can't do pre-rebuttal. It's not allowed. Right? I mean, but we know this. We know it's not allowed. So I don't understand. Like, I just don't understand. And also, the freaking ER doctor legit reading from the medical record, reading from it. And actually, she encouraged him. We're going to see that when I do the recap tomorrow night. I've never. It's like, what? She's like, why don't you just keep your notes up there and read from them? She said something along those lines. It's like, what? What? What is happening? Like, I don't even know. Yeah, I know. For sure. I know. And the defense hardly objects. I know. I actually I try not to point it out every time there's something objectionable with Wally because it would just be too much. It would just get annoying, right? But I still point out some of the times. And it is really crazy because the defense, they so rarely object. And I think that, I mean, they could be objecting nonstop, but we would all be skeletons and this trial would still be going on if that was the case. Yeah, that was bizarre. That was really bizarre. And I covered that live when it was happening. That was such a crazy day because the kids were testifying and nobody knew that was going to happen, or at least I didn't, but then you didn't know when the court cameras were coming back. So I was just sort of killing time and stuff. And I forgot that I had the tab open, and then I was still live streaming, but I was just goofing around. And then it cut back on, and the feed cut back on after he'd already started testifying. So it missed his name and stuff, but I pulled it up, and I had at the time somebody who was watching with me in the live chat who works in is a psychologist. So has medical background. And she was just shout out to Fender, by the way. Fender's command in the chat. And she was just flat, oh my God. The two of us were just what is happening? I don't know what's going on. But she's able to point out a lot of the interesting things that lay folk wouldn't know about, things that are weird that he said, and mistakes and things like that. But there was a lot. I know. I agree with that. I had a thought too, which is that it's interesting that, okay, you think so I hate it whenever I try to think what's Lolly's strategy, because then I'm I should not be giving him that much credit. He does not have a strategy. But let's hypothetically say there's a strategy. It's interesting when you imagine it's just been a disaster. He's not proved anything. But like, if in his mind he thinks he has, like, what if he thinks he's doing a great job? Like, okay, so then it's like, okay, maybe in his mind, his lolly brain, he's like, all right, we're doing great. We got it. I'm gonna try to not laugh as I say this. Like, he's like, yeah, go team to himself because he's the only one talking. And then he's like, I'm gonna finish strong. I'm gonna finish strong with proving the murder. Sorry, it's just not even proving the murder. I'm gonna finish strong with Brian Higgins. It's just and then I'm gonna cherry on top. I'm gonna bring in the kids for the sympathy factor. So they really feel, I don't even know what. I can't even come up with something. Bring in the kids. And then the only thing left to prove is that she was drunk. And then job done. But do you see how there's actually, like, unfortunately, it's like, well, because like I was saying, usually you save the bullshit charge for the very end, right? And it would also make sense that you would have like emotional testimony from family members either first or last. What if he what if he thinks he's proved the murder case and we're just going to hear from, like, what if we just hear from like people regarding the blood alcohol level and her driving or whatever, and then that's it. Nothing would surprise me at this point. I will say that. Who was Trotta? Is that one of the kids? I don't even know the kids' names because I've not done, like I said, I've not done any outside research. Yeah, right. But like, wouldn't that be amazing? Like, what if Lolly just like he's got a couple more people to solidify some of the, drunk driving or whatever. And what if he thinks he's doing a great job? He's clearly not okay. He's clearly not watching any commentary about this trial. That's clear. Because if he was, I feel like we would notice a change in something. Like fewer in reference tos, or fewer in regards to, or fewer what if any's, or who if anyone, or any of the other versions of that. And then there's like a whole other slew of lollyisms as well. So I think he's just like, hum-de-dum-de-dum. Hi, honey, how was your day? Oh, it was great. We really proved our case in chief. I can't even. It's like, like, what is going on? What is going on? Oh my God. Are you saying Lolly's synopsis of was that from opening statements? Oh. So interesting. I wonder, was this from the first day? So okay, I might have missed it. So I will say this much, because remember, I was not planning on watching this trial. I knew nothing about it. And then opening statements were happening. And I was like, well, I just out of curiosity, because I was like, I knew that this was a famous, trial. Like I knew this trial was a big deal. So I was like, well, I want to see the lawyering, right? Like I'm figuring, okay, it's gonna be some like high level lawyering, which I love, right? I love looking at the lawyering. And so even though had no intention of watching it, like I was like, well, let me just see. Well, here's what, so I, again, knowing nothing about it, I turned it on. It was Lolly. And I was like, oh, I guess it's the prosecution. I'm listening. I made it about 5 minutes. And I was like, I can't anymore. So I left, and then I came back, and I think he was still lollygaggling. And then I left, and then I came back, and it was Unetti. And then I was like, holy shit. But then I had to go teach some violin lessons. And so whatever happened right after opening statements, like the first witness, 2 witnesses maybe or something, like I think I missed those. Oh, pre-trial. Okay. I didn't watch anything pre-trial. So yeah, then that's why. Okay. Yeah. Which is great. Like I have, and I'm not looking anything up. So except for like trial schedule. But yeah, I'm only learning what's coming in at trial, like the jury kind of, right? It's that type of thing, which is like, and I really, it's unique. It's unique. It's a unique approach, but I think it's good. As I always say, I don't have to worry about accidentally thinking Lolly's proved more than he has, right? By like learning stuff on my own and then getting it confused. No, I can tell you exactly what he's proved because like literally all I know is what's coming in court. So I can say like firsthand, like that he's correct when he says
There's no evidence of anything in this case.
I can vouch for that. I can vouch for that. Yeah. Absolutely. And that's the other thing. Like I could tell from Unetti's opening statements. I was like, first of all, I was like, holy shit in every way. Like what I just heard was insane. The quality of that opening statement was insane also. The quality of that lawyering was insane. Clearly, this is fucked. And like, I realized very quickly that this is history happening, that we're watching history, like for sure. And so, and it's funny, I'm not the only one. There's a lot of other people who've said the same thing in terms of they had no intention or no plan to watch this trial. And then they caught some of Unetti's opening and that changed everything. So, but I appreciate y'all for being here, and especially those who stayed late here to talk with me and ask questions and everything. But we'll be back in just about a little over 8 hours, I suppose, to see what's happening next on Karen Reed. Yeah. And the thing is like, that's the thing is after the trial, I already have kind of like a list going of what people have been recommending that I go back and watch after. Like then absolutely. Like I was saying too, I could see potentially doing another gavel to gavel deep dive on this trial, like what I did with Murdaugh, where it's all the context, starting from opening statements, but then going back with all the context, but bringing the context in as it happens in testimony. I think that was just so cool. So I potentially that might happen, even though I'm already covering it now. Like I can't rule that out at all. It might be a good trial to do that with in the future too. So KR, when you say KR there initially, are you referring to Karen Reed or Carrie Roberts? Because it was easier when everyone thought Carrie Roberts was spelled with a C, but then we learned it was with a K, and now they have the same initials. Is the snowplow supervisor the guy that drove Frankenstein? Because I feel like they're going to call him, the defense is going to call him in their case in chief. If it makes it past a motion for directed verdict, which won't make any sense if it does, but if it does, then they get to accuse chief. I mean, it's just, I was thinking about this earlier today of how it's just this whole thing's such a disaster, but in terms of learning about it in trial and watching it unfold in trial, it was a disaster from the beginning, but when the solo cups came in, that's when it's like, okay, why are we here? Is this a joke? Are we being pranked? Okay, Carrie, thank you. Okay, I figured, but I just wanted to make sure. So yeah, so I think I don't even have the context to understand the significance of what you're saying here too, but I will go back and watch other things after the fact for sure. Yeah, I will say that I don't think that his injuries are consistent with the damage seen to the vehicle. Like, they don't match each other. And I accidentally. Oh, lucky. Okay, thank you. Okay, Trotta was a supervisor. Okay, cool. Okay. Yeah, I just lucky. That's great. Well, I'm sure we'll hear from him because I remember them talking about Frankenstein. See, that was a great job. That. There you go. Right, because it's unforgettable. Like, no one's gonna forget hearing about Frankenstein. That was a great choice on Unity's part for sure. But yeah, so I accidentally came across the injuries to John O'Keefe, not intending to see them. And just so I know, like, and just but I think even just common sense, even if you didn't see him, which I don't even think the jurors have seen. I think they've only seen the scratches on the arm. It's insane. But I mean, even just hearing about it, because the jurors have already heard at this point that there was no damage to any lower extremities or his trunk or anything like that. I mean, common sense is like, yeah, obviously those two things don't match. But again, we don't even need to evaluate that because solo cups, right? I mean, solo cups. It's like, Oh, thank you. Okay. I remember this. We covered this. I just don't know that I. Okay, I see what you're saying. Yeah. And that's the thing too, right? When you've been following something pre-trial, or you watch a trial and then you watch it again after the fact, and then later on you go back and do it, like what I do with Murdaugh, right? Like I was saying this earlier, there's things that like it's very different because you have so much more information, so you know what to be looking for. Like something like this, it's like I didn't catch that at the time, but I'm sure that I would have, like, if this was like 6 months in the future and I was going like once I don't know how to explain. If I knew all the thing, if I had the information of what to be looking for, like that's not something that I noticed. I mean, but having said that, I noticed everything she said was inconsistent and wrong. Like, that's obvious, right? So maybe that's part of it too, is just like, yeah, obviously she's wrong about every statement she said had a different problem to it. So, but I didn't notice this specifically with the video. I just remember what stuck out to me was that I think I was probably focused on the taillight itself, honestly, and I probably didn't catch the walking in, because I really have I paid a lot of attention to the taillight. That's probably what I was focused on. And because I've had a cracked taillight, and I've cracked my taillight more than once. And so I have personal experience with what that looks like and how easily it happens and all that. And it's one of those things. And luckily, that's such a normal thing. As a juror, you would have to think like that's something that most people are going to have experience with. And what's nice about that is they can assess that themselves, right? Like, they don't need an expert. Well, the prosecution should have experts, right? They should be doing other things than what they're doing. But again, jurors, just regular life experience, most of them are going to have an idea of like what it's like when a taillight cracks. And I think that, again, is enough to be like, human bone and human body is stronger than the taillight. Like, the taillight, if it collides with like a human head, the taillight, I would imagine, is going to get a crack. And the head is the thing that's going to be more intact, versus the other way around, where the taillight hits the head and does lethal damage. It just doesn't. Oh yeah. Yeah, I have more than once. And so it's funny because they look like really sturdy. I think a lot of car parts are like this though, to be honest, where it looks when it's all attached, it seems like, yeah, it's like it's almost like really solid and sturdy. But when you get any part by itself, if something comes loose or a break, then you realize it's almost like make believe in a way, really. Like things that look like solid metal are really just like, to say plastic, it's like flimsier than plastic, some of it. It's really crazy. And like the taillight is one of those things where it's like once it looks all solid, but once you get one little crack in it, it's almost like there's mirrors on the inside or something to make it seem thicker than it is. It's kind of hard to explain, but it's like an illusion, right? That's what I mean. It's like it's hollow on the inside. It's hollow. It looks solid from when you see everything intact, but it's just the actual inside of it is hollow, and it's just a really thin outer layer of plastic. Of course that's possible. Yeah. People crack taillights on backing into things. That's how I cracked mine. I backed into like the first time I cracked a taillight, I backed into it was like a wooden fence. It was a wooden fence or something. It was just something behind me. I was backing up and I was going really slowly. I was in like, in reverse, but I wasn't using any gas. And I was just rolling backwards. And I just very slowly bumped into something behind me, but and that was all it took. So the way that it breaks is it's like chunk isn't even the right word because it's so thin, but it's all one piece. Let me give you an example. Imagine a lake. This is a good example. Imagine a lake that's frozen, but not a place that's been frozen for a long time. Imagine it's a pond. Let's say a pond. And so it's only just frozen over. So you've got that very thin layer of ice on top. Let's imagine that. This is a good example. Really thin layer of ice on top that if you were to poke it with something, like you could easily break it up, right? But let's imagine that you've got that ice, thin layer, and then imagine that you take the end of a trowel or I don't know, something, a shovel or, a stick even, right? And you poke a little spot and then you go over a little bit and then you poke another spot. And what would happen, right? Would the entire pond, all of the ice on the entire pond all shatter? No. What's going to happen is it's going to break that spot off in a large piece, right? It's going to break off from the rest, but that thing stays intact. And the other reason I'm thinking of it that way versus a chunk is because it's thin, right? That's my point, is like the piece of ice, right? Like, again, it's a good example because when you think about a pond or a lake that's frozen over, you look at it and it looks like it's all one solid thing, right? But in reality, it's just one thin layer on top. But it gives the illusion that something is completely solid, which is why people can fall through because they think it's frozen. So yeah, that's a good example. It's just like that. So you get this really thin piece of ice, and I guess it's a chunk only in the sense that it's all one piece. But I wouldn't call it a chunk because it's not weighty, if that makes any sense. Hopefully that makes sense. Hopefully the visual makes sense. So glass shatters, but plastic doesn't. So you just get just imagine anything else plastic. Like, what's another thing that would be comparable? Like, yeah, the ice example is pretty good though. It's just like, it's super thin. It's just super thin. And then you realize, wow, there was nothing on the inside. Like this whole thing is just like empty, right? It's just like reflections. The way the light reflects, it makes it look like it's a full thing. You're welcome. I'm glad that works. Yeah. The shattering thing is crazy. The only way I can imagine that, just from my own personal experience, is if you have the taillight portion that broke off. Like, so where it gets hit, you're either going to get like a small crack in it, which is what we've heard described here, right? But where it cracks, that piece could fall out, but it's going to be all one piece, you know? But like, let's say that you took a new taillight, okay, that wasn't installed, where you had more surface to work with, and then you took like a hammer to it, then I could picture it shattering. Which is interesting because we know her whole taillight is missing in the pictures, right? They took the whole thing out. I don't know. And remember, we heard what's his face, Mr. Red Solo Cup guy, explain how he said that when they took it out, it shattered. Like it shattered in the process of them taking it out. But I don't think he was the one that actually took it out, but that's what he said. I'm wondering if that's a half truth, half lie, because, you know, reasons. But because it's definitely not, and again, the difference though with the ice is it's definitely not as delicate as the ice, right? A thin layer anyway, but like, yeah, but it's definitely more fragile than like glass, I would say. Wait, really thin. Like if you picture your windshield of a car versus a taillight, the taillight is there's not even you really getting compared to taillight is a goner compared to the windshield. Windshield's way sturdier, and think about how thick that is. So, but yeah, I'm glad that explanation helped. So, I almost wish I could get my hands on like, you know, or somebody, right? Almost wish somebody could get their hands on like an actual taillight part, you know, uninstalled from the car so we could take a look and really just see for ourselves, for those of us for people who haven't broken it, you know. But it is so easy. My mom also is really prone to it. She's broken the taillight a million times, and for dumbest stuff. Hail, I think, can take out a taillight as well. Right. I know. Right. Like, again, the only way I can imagine that is if you took a hammer to it, or maybe if you ran over it a bunch of times, maybe. But see, I don't know. I feel like it would need more force. I feel like taking a hammer to it or something. I think you'd have to work pretty hard to get it to shatter, to be honest with you, like that. I think you'd have to work pretty hard because it's fragile, but again, it stays in one piece. The ice example is a good example. It's a specific type of thing that we're describing here where it's fragile in one way, but not in another way. Like it's going to break really easily, but it's going to break off into a piece. So picture like a glacier or something that detaches from the rest of a thing, that's another, I mean, I guess the glacier is going to be kind of thick, but just another kind of example of just the way the ice breaks, right? All right. Well, y'all, we will reconvene here shortly with the rest of this and see who's on the stand. It'll be exciting. If something crazy, if something crazy is happening, I might jump on before 10. I have it scheduled for 10 just in case it's like Lolly is just too much and I'm going to have to watch him at 2 times speed or something. You know what I mean? Just for sanity. So the 10 o'clock is like for safety purposes, right? If it's just like slow droning on and on, plus, you know, then you can skip over breaks and stuff too. But if it's like, let's say that for some reason it's Trooper Proctor or something, then I'll jump on before 10. Absolutely. I really have no doubt of that in my mind about that. Yeah, I mean, again, anyone who's broken a taillight, there's so much in this trial, in this case, that is difficult. But one of the things that is especially difficult is the shattered taillight, I will say. I cannot imagine a scenario that would happen unless you're trying to make it happen. But it would take a specific type of effort. Like, I think you'd have to break it and get it to crack and then pull out the piece and then shatter that piece. I don't think you'd even really be able to shatter it. Like, I imagine you'd have to lay a flat piece on the ground and then take like a hammer to it. And then that's how you would achieve it. But yes, you're very welcome. Very welcome. Hopefully we'll hope to see you tomorrow. And thank you for being here. Shout out to the rewatch crew. I'll have timestamps as well done, hopefully here soon. But I love doing this. I'm happy to cover these trials and talk about this stuff, work it all out together. Thanks for everybody for watching, and thanks for being this squirrel. And I will see y'all here very soon for more Karen Reed. And I'll go ahead and roll the outro.